प्लीज कम।
कविता जी आप भी आ जाओ।
प्लीज कम।
और मेरा निवेदन है कि आप यहाँ जितने भी साथी हैं वो इस गाने में अगर एक लाइन में गाऊंगा आप साथ देंगे तो अच्छा रहेगा। ऐसा नहीं होगा कि एक तरफा ही गा रहे हैं, आप सब भी। हम जुल्मतों से देश को आजाद कराएंगे,
हम जुल्मतों से देश को आजाद कराएंगे।
आवाज वहां से आनी चाहिए थी, आप तो यहीं से चलोगे। एक बार और। हम जुल्मतों से देश को आजाद कराएंगे,
हम जुल्मतों से देश को आजाद कराएंगे।
चाहे जो भी कर लो हम तो बढ़ते जाएंगे,
चाहे जो भी कर लो हम तो बढ़ते जाएंगे।
वो एक ही पल में सारे वादे भूल जाते हैं,
वो एक ही पल में सारे वादे भूल जाते हैं।
वो कहते हैं आएंगे पर ना लौट के आते हैं,
वो कहते हैं आएंगे पर ना लौट के आते हैं।
हम एक एक वादा उनको याद दिलाएंगे,
हम एक एक वादा उनको याद दिलाएंगे।
चाहे जो भी कर लो हम तो बढ़ते जाएंगे,
चाहे जो भी कर लो हम तो बढ़ते जाएंगे।
वो देश प्रेम के नाम पर नफरत फैलाते हैं,
वो देश प्रेम के नाम पर नफरत फैलाते हैं।
वो लूटते हैं देश को दंगे करवाते हैं,
वो लूटते हैं देश को दंगे करवाते हैं।
हम गली गली में प्यार की शम्मा जलाएंगे,
हम गली गली में प्यार की शम्मा जलाएंगे।
चाहे जो भी कर लो हम तो बढ़ते जाएंगे,
चाहे जो भी कर लो हम तो बढ़ते जाएंगे।
ना लाठी है ना गोली है ना राज हमारा है,
ना लाठी है ना गोली है ना राज हमारा है।
ना जेल है ना जाल है ना ताज हमारा है,
ना जेल है ना जाल है ना ताज हमारा है।
हम गीतों से नारों से आवाज उठाएंगे,
हम गीतों से नारों से आवाज उठाएंगे। चाहे जो भी कर लो हम तो बढ़ते जाएंगे। चाहे जो भी कर लो हम तो बढ़ते जाएंगे।
ये रात काली पूछती है क्यों ये काली है,
ये रात काली पूछती है क्यों ये काली है।
किसने हमारी चांदनी हमसे चुरा ली है,
किसने हमारी चांदनी हमसे चुरा ली है। हम जुगनू हर अंधेरे का हिसाब मांगेंगे। हम जुगनू हर अंधेरे का हिसाब मांगेंगे। चाहे जो भी कर लो हम तो बढ़ते जाएंगे। चाहे जो भी कर लो हम तो बढ़ते जाएंगे। जिंदाबाद 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 जिंदाबाद। सब लोग जुड़े।
जिंदाबाद
जिंदाबाद जिंदाबाद जिंदाबाद।
संविधान को जा माने वो क्या देश चलाएंगे,
संविधान को ना माने वो क्या देश चलाएंगे।
संविधान बचाने के लिए हम लड़ते जाएंगे,
संविधान बचाने के लिए हम लड़ते जाएंगे।
जिंदाबाद
जिंदाबाद जिंदाबाद जिंदाबाद।
distinguished guests, colleagues and fellow citizens, we meet here to delve into the recent trends shaping the Supreme Court's engagement with civil liberties and political rights, a realm where our Supreme Court is assumed to be the sentinel and an ever-vigilant guardian arm. The following minutes, I invite you all to join me on a journey through the labyrinth of these trends. It will not be a mere recitation of successes and failures, but a call to engage in a nuanced dialogue. Let us hold the mirror to the judiciary, not to condemn, but to illuminate areas for improvement, to ensure that the scales of justice truly weigh the rights of all citizens, and the march towards a more just and equitable society becomes more assured and less reminiscent of a tiptoe walk it has become. While I'm sure each of us has a wish list of sorts for our panelists, let me lay out the few themes and ideas that the ensuing discussion will likely elaborate on. First, no prizes for guessing at all. The jurisprudence or the lack thereof in matters of bail during pendency of trial. Particularly so in cases involving the Prevention of Money Laundering Act and the Unlawful Activities Prevention Act. Several issues there: delay in adjudication, inconsistency of application of principles. More recently, the acquiescence to the practice of the High Court staying their own decisions to grant bails. These are, I'm just flagging some of these issues that are likely to come up during this discussion. Right? And second, not an unrelated subject, is the court being used as an instrument toward engineering specific partisan political outcomes. It is often said that the court has had a mixed record in protecting citizens' rights against the state. It has always excelled in articulation of the law in favor of rights, and then flattering to deceive when it comes to the application of that articulation. As my learned friend Mr. Gautam Bhatia never misses an opportunity to point out, even at the end of that case of Menaka Gandhi versus Union of India, which is now celebrated to have ushered in a tectonic shift in the jurisprudence and the understanding of the chapter on fundamental rights, the petitioner failed to get her passport back. Despite that mixed record, there are two categories of cases where the court has exhibited its strongest character. One, in cases involving judicial powers or judicial independence. Right? So the striking down of the National Judicial Appointments Commission in 2015 comes to mind. And the second category are those involving direct party or partisan political interests. The court has seldom put its thumb on the scale in determining partisan political outcomes thus far. This is arguably true even in recent history, with the Supreme Court famously setting aside the governor's decisions in respect of invitation to form governments or the time given to prove majority, the 2018 midnight decision in the Karnataka Assembly case, for instance. However, it is hard to miss that with some of the very recent decisions, it has turned a new but undesirable leaf. Splits in parties have become recognized in the case of Maharashtra, with one constitutional authority having been restrained while the other two constitutional authorities having been allowed to proceed to change the status quo. May I venture to say, purely as a keen observer, the proverbial thumb on the scale has been placed by the Supreme Court. Third, sticking to this theme, the question of whether its recent trends relating to bail have indirectly resulted the party in power at the center being able to engineer defections and switchovers for political leaders who are under investigation or trial. If that be so, is there a distinct jurisprudence that needs to be evolved, that specifically keeps in mind the role of the opposition in a multi-party democracy. This differential treatment is not necessarily unprecedented. Already, for instance, journalists are treated somewhat at a different footing, given their role in a liberal democracy. Despite the statement of law that the journalists do not enjoy a higher or more enhanced Article 19(1)(a) rights than any other citizen. Finally, as the last issue that I'd like to flag, the inconsistency of the law on who and when can someone directly approach the Supreme Court under Article 32, which is by itself a guaranteed fundamental right. The dictum in the Constitution bench decisions of Ramesh Thapar and Kochunni, which lay down that the Supreme Court has no power to turn down Article 32 applications by aggrieved petitioners, including on the ground of availability of an alternate remedy to be able to approach the High Court, etc. But we do know that this dictum today is mostly followed in the breach. Granted, I'm sure a number of you will raise that, see, there has been the recent electoral bonds decision, the recent decision in the Chandigarh mayor's case, as Mr. Bhushan pointed out in the earlier session. One must remember, however, that in language, in art, and in law, the exception always goes only to prove the rule, never disprove it. And the rule is the court's increasing inability to contain the Indian state's authoritarian drift. And this expression, authoritarian drift, is the expression that was used in the Economist's piece that came out a couple of days ago on the very same subject. Right, thank you. I hope we have an illuminating discussion. Over to Anjali.
Thank you, Prasanna, and a very warm welcome to all of you to this afternoon's deliberations. I think this session that we are holding right now is very, very significant for all of us as citizens. All of us who want to exercise our civil liberties, who see that how important it is, and especially in today's context, but I would say always in a democracy, to exercise our political rights. And we are seeing how there has been a systematic attack on all those who are exercising their political rights. In a situation where when we exercise our right to free speech and expression, when we dare to question, when we dare to dissent, we as citizens are met with repression. And very often that repression takes the form of cases being instituted against us, cases under the UAPA, under PMLA, NSA, draconian laws where people are put away. Journalists, protesters, people from minorities who are talking about their citizenship, farmers, and we are seeing that they stay in jail for long periods of time. Now, when this happens, we understand that there are executive excesses. But as citizens, where do we turn to in a democracy? The only hope then is the judiciary. The judiciary at all levels, especially and including the Supreme Court. So today we have a very eminent panel who's going to talk to us about the recent trends in the judiciary, where there are cases involving civil liberties and political rights. क्योंकि ये ऐसा सत्र है जो कि देश में सभी लोगों के लिए बहुत ही महत्वपूर्ण है, जहाँ पे हम कहते हैं हम एक लोकतांत्रिक देश में रहते हैं, तो हम कोशिश करेंगे कि इसको थोड़ा सा बाइलिंगुअल करें. अगर पैनलिस्ट अंग्रेजी में बोलेंगे, मैं हिंदी में उसका छोटा सा एक अनुवाद दे दूंगी. लेकिन बहुत ज़रूरी है कि जब लोग अपने अधिकारों को एक्सरसाइज करते हैं, अपने मानव अधिकारों को जब अपने बोलने के अधिकार को, अपने बोलने और अभिव्यक्ति के हक को, उनके ऊपर जिस तरीके से हम देख रहे हैं कि सरकार उन्हें लताड़ रही है, ऐसे में कोर्ट्स और जुडिशरी का एक बहुत महत्वपूर्ण एक रोल बन जाता है। और जब ये दिखे कि जुडिशरी ऑल्सो डज नॉट हैव पीपल्स बैक, कि लोगों की सुरक्षा सही से जुडिशरी भी कहीं नहीं कर रही, कई ऐसे केसेस हैं जिनके बारे में हम सुनेंगे जहां ये एक ऐसी फीलिंग होने लगती है लोगों को, तो ये बहुत ही चिंताजनक है किसी भी लोकतंत्र में। तो अभी ये वाला जो सेशन है, इसमें हम लोग इन्हीं सब चीज़ों के ऊपर बातचीत रखेंगे। और मैं सबसे पहले मिहिर देसाई को बुलाना चाहूँगी, जो कि एक ह्यूमन राइट्स लॉयर हैं और सिविल और क्रिमिनल केसेस तमाम तरह के वो हैंडल करते आए हैं। नेशनल वाइस प्रेसिडेंट हैं वो PUCL के। और मिहिर इज a human rights lawyer who has been dealing with cases on the civil and the criminal side, and he's the national vice president of the PUCL. He has been playing a very, very important role in the courts in upholding our rights and fighting cases related to civil liberties and political rights.
Thanks for inviting me here. I will, in the morning, we spoke, the word perception was frequently used, that people's perception is this, people's perception is that. I think it was used more in a diplomatic sense. What they were talking about was reality and not perception. And I think let's talk about reality now, okay? Let's talk about the reality as it exists. I mean, I'm very happy to be in Delhi today, because such a meeting we could not have organized it in Bombay or in many other parts of the country, because the moment we try to organize a meeting in any of those, and it may be Bombay, it may be Ahmedabad, various other parts of the country, the police will put pressure on the organizers, and they would give some excuse and they will tell us not to have a meeting. So in a public hall it becomes very difficult. So the only people we are left with are our Jesuit friends who are bold enough to give us their halls to organize meetings, despite there being pressure from the police. But that is the situation of civil liberties as it. Here also I am sure it happens in many other places. There was a case in Delhi High Court which reflected that, I think, where participants' names had to be given and all that. So I think that's the level of civil liberties which we are talking about. Let me just talk about 2 or 3 issues, because there is a eminent panel, co-panelists with me. They will also be talking about a number of things. Let me just talk about 1 or 2 things. You know, we are at a situation, we are at a juncture in our country right now where authoritarianism bordering on fascism is already existing. And one of the hallmarks of any authoritarian government is not to allow anybody to dissent. Dissent by voice, dissent by assembly, dissent by protest. That's a hallmark of any authoritarian government. And it is in those times that one expects the Supreme Court, which is the guardian of these rights, to immediately step in and say, sorry, nothing, no more. This is what happened post-emergency, in the sense that you had a whole new jurisprudence being set up, public interest litigation, rights of prisoners. I mean, PIL started with rights of prisoners. Hussain Ara Khatun was referred to in the morning. Similarly, various other, Sunil Batra, Charles Sobhraj, etc., those cases. Bonded laborers. The whole jurisprudence changed, court accepting letters petition, court setting up committees, court setting up, issuing guidelines for various, to protect against various human rights violations. This is what happened post-emergency. To what extent it was successful is a matter for another day for debating, but at least the intent was there. Today we see a complete lack of intent of that kind of on part of the Supreme Court, including, I would say, the Chief Justice of India. A complete lack. Look at the situation. I mean, just let me tell you one or two instances. Take UAPA, for instance. In order to crush dissent, one of the easiest way which the government has found is to use UAPA. You arrest people. Earlier, okay, UAPA, anti-terror laws were also used. Now they are used much more, and the bail provisions are being interpreted much more stringently by the courts than they were ever before. So you have a large, and half the people who are arrested today under UAPA are not arrested because some incident happened. Okay. Take for instance Bhima Koregaon case. Nothing happened. Stan Swamy was not charged with having bombed some place. Gautam Naulakha is not charged with having set up a landmine somewhere. No incident happened. Okay. So you have a situation whereby people are being put in a prison not because of any incident which has happened, any bomb blast which has happened or something like that, but because they fear, because there is an apprehension that these are either jihadis or urban Naxals, the two standard clauses. And what is the Supreme Court's response? First of all, it comes out with the classic, locus classicus called Vatali judgment, which basically takes away all the rights of any accused under the UAPA Act to be released on bail, given by Justice Khanwilkar. Khanwilkar has many more things to his credit, I will come to them. Okay. So that is one thing, Vatali's judgment. Supreme Court tried to push back a little. Najib's case, for instance, saying that if you have spent that right to speedy trial is also a fundamental right. If you spend much more, I mean, if you have spent substantial time in jail, then you should be released on bail, irrespective of what the allegation against you are, provided the trial is going to take a long time. You had some judgments like in Anand Teltumde's case or Vernon Gonzalez, Arun Pereira's case, Tawa Fasal's case, etc., where people were released by using a mix of both these aspects. And then what happened day before yesterday, or 4 days back? You have this judgment which says that as far as these kind of laws are concerned, UAPA is concerned, it's not bail but jail which is the rule. I mean, how proudly they say it, how proudly they proclaim to the world. Okay, this is what Supreme Court of India is going to say, that bail, jail not bail is the rule. Okay? And look at the consequence of that. 3 days back, a sessions court rejects a bail of a person who has been in jail for a long time with a novel argument. When it is said that this trial will take a long time and and he has spent about 4 or 5 years in jail, why are you not releasing him? A novel argument that look, he's been charged with 4 different offenses. Everybody gets charged with 4 different offenses. I mean, anybody who is charged in UAPA is always charged with 4, 5, 10 different offenses. Look, he has been charged with 4 different offenses, and it is possible that under the Criminal Procedure Code, there is a possibility that once he is found guilty, the sentences might run not concurrently but consecutively. So the total amount he might have to spend in jail might be 40 years, 50 years, 60 years, we don't know. So how can we release him on bail? Now this logic is going to catch up. And this logic is going to catch up, and this is going to, go on. Same thing with PMLA. I mean, everybody, see, look at the situation that today the Supreme Court in Capital Bonds case says that we have to take judicial notice of the fact that money is used extensively in elections. They actually say that, observe that in the judgment. that we must take judicial notice. Why can't you take judicial notice of the fact that UAP is being misused? Why can't you take judicial notice of the fact that PMLA is being regularly used? Why can't you ask? Why do you have to always bow down to what the Solicitor General of India says? Even though he is not even a constitutional post. Solicitor General is not a constitutional post. And anytime somebody raises the issue of Kashmir, he jumps up and says, that, oh, we know who they are acting on behalf of. They are acting on behalf of our neighboring nation, etc., etc. And the judges don't have the gumption or the guts to haul him up. They don't have the guts to tell him that, Mr. Solicitor, just sit down, shut up and sit down. That's what should be done. In USA, you have, the Supreme Court is known by the Chief Justice, Roberts Court, Warner Court, Rehnquist Court, etc., etc. Today, the Indian Supreme Court should be known as Tushar Mehta's Court. That's the kind of situation we have come to. That's the situation we have come to. And nobody has the guts to call him out and say that enough is enough. That's look at the situation. And in that kind of, repeatedly, I forget about this issue, but repeatedly, Supreme Court says that, look, the people are not convicted, especially in sensitive matters. And sensitive, political sensitive matters. People are not convicted because the investigation has been botched up. Repeatedly in judgment after judgment, you will say, Supreme Court saying the investigation has been botched up. Why is not a single policeman who has botched up been taken to account? Why has a single policeman not been hauled up? Why has a single policeman not been sent to jail? If repeatedly you come to the conclusion that these people have botched up, instead, what does the Supreme Court, led by Justice Khanwilkar, does? First of all, any whistleblowers or civil society activists who are trying to help people, who with total boldness approach the court for years together, use the legal mechanism to bring justice to the people who are either tribals or who have been, who have been victims of communal riots. What does the Supreme Court do? Send Teesta Satalwat to jail? Send Himanshu. Himanshu was here somewhere. I don't know where he is. Is there? He was there. He is gone out. I think he doesn't want to be part of this. Send Himanshu to jail. Boldly, of course, Himanshu says, I am not going to go to hell. I am not going to pay the fine. That's the kind of bold people we have with us. But these are the people who should be celebrated by Supreme Court. Instead, the Supreme Court says, send them to jail. What have we come to? What kind of civil liberty protection will get? Okay? Unless there is a Supreme Court. And I personally feel that change only can be brought about by people outside. Look at what is happening. Even in Pakistan, people were protesting about concerning the Supreme Court on the streets. In Israel, when they tried to do the appointments, the appointment procedure was to be changed. Millions of people came on street. I of course wish that millions of people would come on street in Israel supporting Gaza, but that's a separate issue. This is what is happening in other countries. Here also we need to put pressure, because these things are not going to change by somebody's conscience suddenly awakening on one fine day. This can only change through pressure. This can only change through street pressure. Okay? We can keep on arguing jurisprudence till the end of our lives. Okay? But unless we are there on the street protesting against what is happening, coupled with, of course, fights in, because judiciary is a space we cannot give up. Other side may want us to give it up. We don't want to give it up. It's a space provided to us by the Constitution. We are going to use it. But using the judiciary alone is never enough. Courts are never answer to all your problems. I always believe that major changes come through street battles, not through courts. Okay? And that's what we have to focus on. Okay? Besides focusing on what is happening in courts, besides fighting out, besides taking, look at the situation. I mean, I have various questions. In courts, out of politeness, you don't ask the judge a question. So you say, I ask myself a question, which is a euphemistic way of telling the judge that I'm asking you a question. Okay? But that is how we do it in court, that I ask myself a question. So let me ask myself a question, one or two questions. Okay? First question, habeas corpus means produce the body. That's a literal way that you produce, that you get that person to the court. Okay? If somebody has been kidnapped illegally, detained illegally, you bring that person to court. When it comes to Kashmir, habeas corpus means you go to the body. Okay? You go to Kashmir. Okay? You go to Kashmir and you meet him, but don't say anything else. Your freedom of speech will be restricted. Your right to assemble, right to protest is not going to be given to you when you go to Kashmir. What is this going on? Supreme Court saying this. Look at Hadia's case. Finally, of course, Supreme Court had no option but to allow her to go with her husband, because she came to court and said yes. But even then, at the end of it, a bench which included Chandrachud says that NIA should continue investigating in this love jihad. What is the basis for saying all this? I am not even talking about Gyanvapi and Ayodhya and all that, because, I mean, what do you talk about them? You know, what do you say about them? But look at this kind of a situation which is happening, where for a habeas corpus, when it comes to internet ban, what is the highest the Supreme Court does? It sends the matter back. Supreme Court doesn't set it aside. When in Pegasus case, the Union of India refuses to file an affidavit despite repeatedly being called upon by the court. If a private citizen had refused to file an affidavit, what would the court have done? A, court would have heard me up for contempt, or the court would have said that I am making a presumption against you. Okay. What does the court do? No, they don't want to file, what can we do? You know, now this kind of a helplessness in front of the executive was never seen earlier. It is something which has happened in recent times, and I feel I'll end by that I think civil liberties are as much under threat from the Supreme Court as they are from the executive. So let's all jointly try and fight it. That's it. Thank you.
थैंक यू वेरी मच मिहिर, और आपने बहुत सारी महत्वपूर्ण बातें कही। सारी ट्रांसलेशन के लिए तो समय नहीं है, पर मुख्य बिंदु सवाल उठाए आपने, कुछ बहुत सटीक सवाल उठाए। एक सवाल आपने कहा कि जब यूएपीए जैसी जजमेंट, जैसी कानूनों के ऊपर जजमेंट्स आती हैं, जैसे वटाली जजमेंट है, जो कि लोगों के अधिकार के ऊपर एक तरह से अंकुश लगा देती है, जहां पर अब सुप्रीम कोर्ट में हम कह रहे हैं कि जेल होनी चाहिए, बेल नहीं, ये एक तरीके का प्रिंसिपल अपहोल्ड हो रहा है और स्पीडी ट्रायल्स की बात नहीं हो रही है। तो आपने कहा कि पीएमएलए, यूएपीए जैसे सारे जो मामले हैं, इनमें इस तरीके की जजमेंट्स क्यों आ रही हैं, ये सोचने की और पूछने की ज़रूरत है सुप्रीम कोर्ट से। आपने बात करी सॉलिसिटर जनरल की, और आपने कहा कि सुप्रीम कोर्ट आज एक तरह से सॉलिसिटर जनरल का कोर्ट हम कह सकते हैं बन गया है। तो क्यों सवाल नहीं पूछती सुप्रीम कोर्ट? हमारा सवाल है कि जब वो अलग अलग तरीके की बातें करते हैं, ऐसी बातें करते हैं जो कि बिल्कुल भी लोगों की जो अधिकार हैं उनका हनन करती हैं, तो उनसे कोई सवाल क्यों नहीं पूछा जाता? आपने कहा कि बार बार सुप्रीम कोर्ट ये कहता है कि पुलिस अपना काम सही से नहीं कर रही, केसेस बॉच अप हो रहे हैं, तो पुलिस की अकाउंटेबिलिटी क्यों नहीं मांग रही सुप्रीम कोर्ट? ऐसे मामलों में जवाबदेही फिक्स क्यों नहीं कर रही है? आपने ये भी सवाल किया कि वो जो तमाम लोग जो लोगों के अधिकारों की लड़ाई लड़ रहे हैं, जिन्हें कि सुप्रीम कोर्ट को सेलिब्रेट करना चाहिए, सुप्रीम कोर्ट उन्हें ही जेल में क्यों रहने दे रही है, क्यों जेल भेज रही है अलग अलग केसेस के अंदर? ज्ञान व्यापी और अयोध्या की तो आपने कहा कि आप बात नहीं कर रहे हैं, लेकिन आपने ये कहा कि कोर्ट आज कहीं पर एकदम घुटने टेके हुए क्यों दिखती है कई केसेस में सरकार के सामने, एग्जीक्यूटिव के सामने। पेगासस जैसे केस में जब सरकार को कहा जाता है कि आप एफिडेविट फाइल करिए, वो एफिडेविट फाइल करने से इनकार कर देती है सरकार, तब भी कंटेम्प्ट नहीं होता। तो ऐसे केसेस में जहाँ पे बहुत क्लियरली कंटेम्प्ट हो रहा है एग्जीक्यूटिव के द्वारा, वहाँ पर भी हमारे देश की सुप्रीम कोर्ट खामोश क्यों है? इतनी अगर सुप्रीम कोर्ट हेल्पलेस दिखेगी और बेसहाय दिखेगी एक तरह से, तो कैसे फिर लोगों का उम्मीद और भरोसा जगा रहेगा हमारे देश के संविधान में और हमारे अधिकारों में? बहुत बहुत शुक्रिया आपका और मिहिर। और आई एम गोइंग टू इनवाइट Trideep Pius now, because we are going to keep hearing some of these issues. Trideep is a very, very well-known lawyer who has been taking some very, very significant cases to court. आज सुबह से हम लोग बात सुन रहे हैं उमर खालिद की. Trideep is also a lawyer for Umar Khalid. There are many, many cases that he's taken. He's teaching at the NLU in Delhi, Bangalore. He's also teaching at the law universities in Hyderabad, Odisha. And he's been working tirelessly in the courts to try and uphold people's rights and civil liberties. And Trideep, as you speak to us, also I think one question that also came up in the morning session was that a couple of days ago, you took back the case of Umar, and there were other cases also that were withdrawn from the Supreme Court, where it was said that there was not much hope for justice, and therefore you'd like to go back to the lower courts. So please also, if you could shed some light on that. Trideep, I request you to come here and speak, because I'm told that those mics are not functioning too well. So,
They work?
they're not connected to the mic screen. So.
Am I audible? Yeah. Thanks a lot for this opportunity. In fact, I'm quite intimidated and nervous because the panelists are Dr. Mohan Gopal, and there was even a judge and Mr. Kapil Sibal. So it's a little intimidating for me. Nitya is sitting there. I'm always nervous when she's there. She knows also. That's the worst part. I mean, to tell you how I compare with this panel, I came to Delhi for the first time in 1993. I did not know Hindi. And I was sent by the person with whom I was interning to Prashant Bhushan's office. I called him and he said, "Aap court aa jana, humse mil lena." So I went to the erstwhile 6 and 7 and 8 and 9, one of those courts. No cell phones those days. And there was this gentleman with grey hair in his 40s who was arguing against Prashant Bhushan. His name was Kapil Sibal. He had 14 cases that day, and they were opposing each other. And then I sat in the car with the other interns in Mr. Prashant Bhushan's car. There was another lawyer with him who was Mr. Shanta Bhushan. I mean, like, I was in my third year of law, and since then I've been looking up to these people, and now you're asking me to speak on the same panel.
it's a bit intimidating. Let me start. I will not be giving a speech. I will just be speaking about some issues which I flagged. So the issues which I flagged is, I just watched John Oliver's latest episode on courts. YouTube is very important to my life. I wish that all of you go back and see it. The complete abandon and lack of fear with which he criticizes the present Supreme Court of the US is something that all of us, our society, our courts, everybody should learn from. I mean, so fearlessly. In fact, he says in the last, when he's standing in front of the motorhome that Justice Clarence Thomas has bought, I mean, representing the motorhome that Clarence Thomas bought in 1999, he says, I'll give you the 2024 version if you give up being a judge. He says, I don't know how this is legal, or this must be illegal somewhere. Before he points at the motorhome and he, like just criticizes Justice Clarence Thomas, even using cuss words at some points of time. And I'm thinking to myself, I mean, if John Oliver sitting in that position says, this must be illegal somewhere, he clearly knows what could visit him for saying that. So, okay, I'm just going to speak based on my experiences. I have flagged some judgments to compare for you people. And the first thing which occurs to me when I start off on that comparison is inconsistency. And when I say inconsistency, I refer to how things turn out depending on who the petitioner is or who the matter comes before. As usual, like in these gatherings, I will not be taking names and you will be doing your guesswork and you're welcome to do it. The first thing which occurs to me before I come to the inconsistencies is there is a new modus which operates, which I'm seeing from the kind of FIRs we deal with. There are certain persons who speak in Parliament about something that they are outraged by, which mostly is a point of view or speech, and immediately thereafter, that is tweeted by some other important persons, and then those tweets are carried all evening for about 3 days on important news channels, and about the 4th day or 5th day, it becomes an FIR. And this modus has somehow come to stay. So it has come to stay in such a way that when we see the speech in Parliament, we wait for the tweet, and then we wait for the evening news, and then we know that this is the FIR and this is the person, and then I've known people to sign wakalatnamas, drop into lawyers' offices. This is the way in which a UAPA case proceeds, which is outside of the CRPC. I mean, there's lots of things which the other speakers will tell you which is outside of the CRPC, but this is the pattern which I have gathered. Second is, we are always looking at the roster to see where our matter is going, and I think that's really wrong. But unfortunately, it depends on who the petitioner is and who the matter is before. I wonder from that point of view, without going into any more detail, why a 3-judge bench in Ranjit Singh Brahmajit Singh Sharma reads so well, is so liberal, as opposed to a 2-judge bench in Zahur Ahmad Shah Watali. I'm just leaving it for you people to decide. And then in between, there is an accident called Vernon Gunjalves. Now, let me come to some inconsistencies. Ranjit Singh Brahmajit Singh Sharma simply says that, look, don't get too enamored by what the allegations are. Take an overall view and try to see if at the end of the day there is a likelihood of conviction. If there isn't, take a broad view and release the person on bail. Don't take it literally that when a person is supposed to be not guilty for the purposes of bail, it should not be equated with a judgment pronouncing him not guilty. That judgment is actually approved by Vatali. Vatali says we stand by that, we agree with that judgment. But for some reason, Vatali says, take what is stated by the charge sheet and the allegations made in the FIR to be correct unless proved otherwise at the trial. This much of Vatali has been used to deny many an accused bail. And what is sad about that is that Vatali goes one step further. There is a particular sentence in Vatali which goes, it must be good and sufficient on the face of it to establish a given fact or the chain of facts constituting the stated offense unless rebutted or contradicted. But the sentence prior to that says, the accusation against the accused concerned in the first information report must prevail until contradicted and overcome or disproved by other evidence, and on the face of it show the complicity of such accused in the commission of the stated crime. It must be good. This part is missed out by everybody, every court. It must be good and sufficient on its face to establish a given fact or the chain of events constituting the stated offense. Numerous times in several bail applications, we have read this sentence out to the judge, stating that the allegation or the statement under 161 or the document on the face of it, and this I'm referring to several of us here arguing the very Vatali case at the arguments on charge stage or FIR 59 in Delhi. But somehow this part is never, and none of them, I must say with seriousness, because as a lawyer I've appeared in both these cases, none of them make out a good and sufficient case on the face of it. So Vernon explains it and says that it's not as if you have to simply take what is stated in the charge sheet to be correct. You have to wait to see whether it makes out the offenses. Vernon is a later judgment. It doesn't differ with Vatali. It draws from Vatali and makes out a case for a judge to assess material before him or her to see whether the offense under UAPA is made out. And then comes this strange judgment that Mihir just referred to. It's so strange that I think some parts of it should be read. I wish I actually had kept the suspense and let you people guess for yourself where this chapter came from. The conventional idea of bail jurisprudence vis-a-vis an ordinary penal offense, that the discretion of the courts tilt in favor of the oft-quoted phrase, bail is the rule, jail is the exception, unless circumstances justify otherwise, does not find any place while dealing with bail applications under UAPA. The exercise of the general power to grant bail under UAPA is severely restrictive in scope. The form of the words used in the proviso shall not be released in contrast with the form of the words as found in 437 may be released, suggests the intention of the legislature to make bail the exception and jail the rule. I think it's self-explanatory that you go through, when you have a statute which is oppressive, all the courts have done so far is make every effort, and Najib is like a testimony to that, every effort to ensure that people's liberty is protected. This judgment goes on to distinguish Najib, which is strange because Najib doesn't hedge time spent in custody as a violation of fundamental rights or human rights. It doesn't hedge it with any conditions. It simply says that a court is not bound by 43d(5), the restrictive provision of UAPA, if the time spent is disproportionate to whether the trial has started, whether the trial has progressed, etc. And for some reason, this judgment says Najib doesn't apply. And this is a two-judge bench which does not deal with Vernon. I just come back to my original point with regard to inconsistency. Why does Vatali read like that? Why does Ranjit Singh, Brahmajit Singh Sharma read like that? Why does this judgment called Gurvinder Singh read like this? Why is everything so dependent on personalities? And every judgment which has dealt with UAPA has gone on to say that the test of prima facie under the UAPA is lighter than NDPS, than PMLA, than the Companies Act, the SFIO provision, that is 212. But however, if you take statistically, it is my understanding, subject to correction, that more people are in custody in UAPA and finding it difficult to get bail as opposed to those who manage to get bail under PMLA and SFIO, and now with the progressive judgments of Supreme Court in the Supreme Court Legal Services Committee judgment under NDPS as well. And you will know that a bulk of the people in custody in UAPA are able to meet that Vatali test, but several courts just refuse to read it. That is good and sufficient on the face of it. Now let's come to the most interesting new statute, this new fashionable statute. It's like Zara. It's called PMLA. So PMLA is very interesting because you wonder whether there's a need for it. What does PMLA do? It's supposed to take over assets that are the result of laundering of money, which is money which is got out of as a result of crime, or PMLA prosecutes you for using that money. Did we not have a mechanism before this? We did. Could we have applied that mechanism to every statute, every criminal statute in India? We did. That statute which can yet be applied is called the Criminal Law Amendment Ordinance of 1944. What's the problem with applying it? The problem with applying it is the Criminal Law Amendment Ordinance of 1944 clearly says that it shall apply only to the accused and to the properties of the accused, and it shall apply simultaneously in the same trial, which is the correct thing to do. And if the accused has gotten rid of that property by means legitimate or illegitimate, then you go after the accused. Don't go after his relatives, his mother, his father, his uncle, his buyer. In PMLA, you have accused who have no clue about what went on in the predicate offense. The predicate offenses in the schedule are such simple offenses where people, regularly get bail, but I wonder how this PMLA, which is a fallout of that offense, makes it so difficult for you to get bail and what the justification is. Now, instead of reading out from Vijay Madan Lal Chaudhary, I can just tell you that Vijay Madan Lal Chaudhary upholds the twin conditions for bail and says that the previous judgment in Nikesh Tarachand Shah is wrong, or no, or doesn't apply anymore, because it simply says, well, Kartar Singh had it and terror was a worldwide phenomenon. Now FATF, whatever that financial action task force, says that money laundering is a worldwide phenomenon, so therefore the same thing should apply. Literally, PMLA, the Vijay Madan Lal Chaudhary, whilst upholding it, equates terror with money laundering. In my understanding, again, a personal point of view, it is easy to get hold of the tribal, the marginalized, the minority, and other such opponents who don't have a way to protect themselves or are poor, and embroil them in UAPA offenses where planting is easy, where attributing material recovered from here and there is easy. But you may not be able to do that with a political opponent who is well heeled in society, who is difficult to embroil in a case. It's my personal opinion that PMLA is a legislation which is being used against persons who dissent but who cannot be easily embroiled in a UAPA type case. It's for them. So you start with a scheduled offense on them, and then you later on move on to PMLA, and suddenly the draconian bail provision visits you. It's a well thought out plan, because you had a legislation which you could have attached. The Criminal Law Amendment Ordinance has been attached under Section 18A of the Prevention of Corruption Act to the Prevention of Corruption Act. So you could have done that for others. But no, you've come up with this PMLA which can attach any property, make anybody an accused, sometimes even when they were not there in the predicate offense. And it is used against people who don't even speak. You see, people who've spoken vocally against the government, they've used 153A, 153B, UAPA, defamation. Depends, the attack comes from all sides. But let's assume you're a political opponent and you don't speak. You fund, or I don't know, you're just a political opponent. You're just not in favor. I think PMLA is a judgment, is a legislation which is being used there. Just some inconsistencies I wanted to point out in PMLA. There is extremely progressive good judgment passed in recent times called Pankaj Bansal, which not only said that PMLA requires you to give grounds of arrest in writing prior to arrest. It also said that PMLA contemplated this. It is in tune with the Constitution of India, and please comply with this, or else the person is entitled to bail, to be released. This judgment did not say, for God's sake, it did not say, we've made up this new rule in our heads and we've written it in our judgment and it will apply henceforth. It just, as a word of caution, said, henceforth you shall give. Quick on the heels of that, you have this judgment called Ram Kishan Arora, where it says it's prospective. It just doesn't make sense. It's similar to Gurvinder saying that Najib doesn't apply. Similar to that is Ram Kishan Arora saying Pankaj Bansal applies only prospectively. Meaning to say, and these are all Supreme Court judgments, meaning to say Pankaj Bansal being a cut-off date, all arrests beyond that are forgiven without grounds of arrest being given in writing. I didn't even know I'll approach that. She's saying I've got 2 minutes left. I didn't even know I'll last that long. Just wanted to say that the slide for me, at least in my recollection, the slide that we are talking about in the court's judgments, sort of leaning against liberty. For me, the slide started with Surendra Gadling, NIA versus Surendra Gadling. I mean, Hitendra Vishnu Thakur was so clear that if you wanted to move from a 90 to a 180, you needed to have an independent prosecutor's report supporting the increase of time from 90 to 180. And Surendra Gadling doesn't make sense. In fact, Hitendra Vishnu Thakur said it cannot be you forwarding the IO's report. You have to write that report. Hitendra Vishnu Thakur takes so much pains. In fact, it's very interesting. The language, sorry, not Hitendra Vishnu Thakur, Gadling, that is NIA versus Gadling, takes so much pains to somehow dilute Thakur. In fact, there's a word used in Gadling. I don't know who does this. We are not able to persuade ourselves to agree with the conclusion of the single judge. You either disagree with him or you agree with him. I don't know why you have to be persuaded. I think for me, the slide started with Surendra Gadling. And then there is an interesting thing which I noticed. The Delhi High Court said that the exception to PMLA is 2. 245 of the PMLA is 2 of them. One is if the accused is a woman, and the other if the accused is sick or infirm. And while doing so, Delhi High Court said it doesn't matter what kind of woman, please don't classify her as educated woman, uneducated woman, whatever. The statute did not contemplate it. You don't do it. And the Supreme Court upheld that judgment. So Preeti Chandra got bail on that basis. And you would have thought that that's progressive. And then we come across nowadays, the educated and the well-placed women in society engage themselves in commercial ventures and enterprises and advertently or inadvertently engage themselves in illegal activities. The last thing, I think that was self-explanatory. The last thing is, what really shocks me is the number of High Court judgments releasing people on bail that either get stayed or High Court stay themselves and then Supreme Court just extends the stay. There's a lot of inconsistency going on here. It's like basically it really depends on who's your client and who you are before, and that's not a good thing. Thank you.
थैंक यू वेरी मच त्रिदीप. त्रिदीप ने बहुत सारी बातें डिटेल में और टेक्निकल मुद्दों को उठाते हुए करी, लेकिन जो एक ब्रॉड चीज़ समझ में आ रही है वो कह रहे हैं कि आज अगर हम जाते हैं कोर्ट के सामने तो जो एक समझ में नहीं आती चीज़ कि क्या होने वाला है, कानून में क्या लिखा है, संविधान में क्या लिखा है, हम सब जानते हैं, लेकिन आप कौन हैं जो जा रहे हैं कोर्ट में और किसके सामने आपकी सुनवाई होगी, ये एक बड़ा मुद्दा आज बन गया है और लॉयर्स को इसके साथ में डील करना पड़ रहा है. उन्होंने बहुत सारी जजमेंट्स के अंदर से हमें चीज़ें पढ़ के बताएं कि कैसी अलग अलग जजमेंट्स आ रही हैं एक ही मुद्दे को लेकर, और समझ में ये आ रहा है कि यूएपीए और पीएमएलए एक तरह से साजिश की तरह से इस्तेमाल हो रहे हैं लोगों के खिलाफ। ये साफ समझ में आ रहा है। जो लोग आवाज उठा रहे हैं उनके खिलाफ पीएमएलए, यूएपीए जैसे से कानूनों का इस्तेमाल हो रहा है, लेकिन जो जुडिशरी है वो अलग अलग आवाज में इसको बोल रही है, अपनी एक मत से नहीं उसको अप्रोच कर रही, और ये बहुत ही खतरनाक है। और उनका यही उन्होंने कहा कि जो जिस तरीके के अब हम बात सुन रहे हैं, जो पहले भी सुनी कि जेल अब नॉर्म है, नियम है, बेल नहीं, ये बहुत ही खतरनाक है सिविल लिबर्टीज के लिए और पॉलिटिकल राइट्स के लिए। बहुत बहुत शुक्रिया आपका त्रिदीप, आपने इन सब चीज़ों के ऊपर बात रखी। आई एम गोइंग टू रिक्वेस्ट प्रोफेसर मोहन गोपाल to please speak to us. He was the director of the National Judicial Academy, was the founder chair of the National Court Management Systems Committee of the Supreme Court of India, is also a former director of NLSUI Bangalore, and we all know him for his work on reforming the legal and judicial institutions. Professor Mohan Gopal.
Thank you very much, Anjali, for that generous introduction. And I have the benefit of listening to the excellent introduction by Prasanna and the remarks that followed. And Prasanna talked about the feeling that he has that the court is kind of drifting towards something. I just wanted to let him know that the sum and substance of what I'm going to say is that it is no longer drifting. This dictatorship is no longer drifting. It has reached its port, called Tanashahi. It is there. We are there. We are no longer drifting. And we are still under some kind of illusion that this is a kind of process that is taking place. So we now have to recognize that we are in a state or in an authoritarian state. And when I spoke here last in this forum, I suggested that there are two types of judgments that are emerging in our country. One I called constitutionalist, where the judgments very clearly stay within the framework of statutes and the Constitution as the Grundnorm, the basic foundation from which it draws. It will never go outside the Constitution. When I say Constitution, I mean the content of the Constitution established by accepted judicial precedents. So there is also in the constitutionalism an adherence to established unwritten conventions of judicial interpretation, which are at the heart of maintaining the Constitution, but are not in the Constitution or in any statutes. So one type of judgment is a constitutionalist judgment. The other kind of judgment is what I am calling a theocratic judgment, where the judgment comes from an assumption that we have to reach beyond the Constitution into religion in order to anchor the judicial decisions in a set of norms and normative values. And that is the vision from which increasing number of judges, closer, okay. That is the place from which the theocratic judgments are emerging. And I think I would like to look at the approach of courts to civil and political rights from a bigger picture to understand what is going on in this context. So if you look at what theocratic judgments are doing, we have to understand what is going on. And I would like to use a metaphor to understand what they are doing. Okay. And that metaphor is, look at what happened to Babri Masjid and the Ram Temple. On December 22nd, 1949, in a centuries-old structure, which is built on the foundational belief that God is abstract. God cannot be described, cannot be worshipped in any form, that God is abstract, is a force, and and it's a place where people come together to worship that concept of God. Into that place was brought in or appeared some idols of Ram Lalla, which is anchored in a completely different religious concept, completely different, completely opposed religious concept. It took nearly half a century. So at that moment, in my view, the fundamental nature of that building was altered, because something completely subversive to the theology underlying that building was introduced into that building. And its fundamental character changed. We could have said this masjid is drifting towards a temple, but actually that masjid was no longer a masjid because its fundamentals had been broken. So what the equivalent, the metaphor we can, using this as a metaphor, what's happening in the judiciary is that in 1950, for the first time in the history of the subcontinent, we constructed a polity which is based on on a set of fundamentals that has no place for religion. That is based on a common citizenship, based on political ideas which are enunciated in the preamble of equality, liberty, fraternity, dignity, socialism, secularism, and rooted in the idea of democracy, which comes from two words. Demos means common people and kratos means power. So it comes from the fundamental principle that power comes. In fact, in the Constituent Assembly Objectives Resolution, which was the first document adopted by the Constituent Assembly, it says that in independent India, all power and authority shall emanate from the people. Not from God, not from a religious text, but from the people. So it was on the basis of these fundamental principles that were made sacred. Sacred has many meanings. One of the meanings is immortalized. So these principles were considered immortalized or immortal, and on these principles a new polity was built, which would be completely free of any other idea. Now, if you take this as a space which is based on a foundation of what we call secularism, which means regardless, irrespective of religion, there's a different, independent set of principles on which this polity is constructed. These theocratic judgments are like the Ram Lalla idol. They're bringing in the theocratic idols, IDOLS, into that space. And we have a number of examples of that. We have the Ram Mandir, the annex to the Ayodhya judgment. We have the hijab judgment. We had a hijab judgment declared that dharma is constitutional law. And the only dharma they're referring to really is Sanatana dharma. Could be referring to it. It's impossible to reconcile that with anything else. The addendum to the, I spoke about this last time in more detail. There's no time to go into it in detail. But there are a number of judges. The addendum is pure theological belief. So imagine an edifice, a structure, which is our polity. And the most sacred foundations of that structure are standing on a belief that all power comes from the people. And religious belief has no space in the use of that power. And into that space you are bringing in idols, religious idols, through these theocratic judgments. And we are still believing that we may be just drifting towards that. But the fundamentals of that structure have been already broken. It may take half a century or much less to actually change the formal structure, to bring down, to demolish the structure and construct a new theological state. And that construction is now going on actually. And if you want to understand the basis of this, this theocratic state, then we have to look at, I'll just get a passage from the Constituent Assembly, where there was, I mean, there's no time to get into any detail of any of this, but on 3rd December 1948 in the Constituent Assembly, there was a debate on the right to religion, Article 25. And Sri Loknath Mishra said, and I'm now reading, "Sir, we have declared the state to be a secular state. For obvious and for good reasons we have so declared. Does it mean that we have nothing to do with any religion? You know that propagation of religion brought India into this unfortunate state, and India had to be divided into Pakistan and India. If Islam had not come to impose its will on this land, India would have been a perfectly secular state and a homogeneous state. There would have been no question of partition. Therefore, we have rightly tabooed religion. And now to say that as a fundamental right, everybody has a right to propagate his religion is not right." So Mr. Mishra is opposing the language that you have the right to propagate religion. Do we want to say that we want one religion other than Hinduism, and that religion has not yet taken sufficient root in the soil of India, and do we taboo all religions? Why do you make it a secular state? The reason may be that religion is not necessary, or it may be that religion is necessary. But as India has many religions, Hinduism, Christianity, Islam and Sikhism, we cannot decide which one to accept. Therefore, let us have no religions. No, that cannot be. If you accept religion, you must accept Hinduism as is practiced by an overwhelming majority of the people of India. With the introduction of religious ideas, into the practiced by an overwhelming majority of the people of India. So it was very clearly said in the Constituent Assembly by a certain group that if you're going to give status in law to any religion, it has to be only to Hinduism. And the moment that India departed on this unconstitutional idea of Sarva Dharma Samabhava, the Congress is responsible for that. Whereas and said we are not, and the many judges, many lawyers have argued that we don't follow the French idea of laicite. On what constitutional basis, on what jurisprudential basis did they come to that conclusion? Whereas, in fact, the idea clearly was there is no soft secularism or strong secularism. There is only one kind of secularism, which means that there is no place for religion in the polity. So when we opened up to other religions, that gave the opportunity for this argument to succeed and prevail, that India must become a Hindu state. That Hinduism is not to compete with other religions in this country. And so we understand now that these theocratic judgments are coming from a space to establish a Hindu Rashtra. That is only a packaging in order for a ruling oligarchy to entrench itself and gain control over the country through an authoritarian, totalitarian state, as we see in many parts of the world. But the packaging and the energy that they are using and the energy that they are deriving to take this project forward is the idea of a Hindu religion. And unless we counter that idea of a Hindu religion, we cannot counter this. So how do we understand this and how do we move forward? That's really the question. And before I get to that as the last part of my remarks, I also want to go a little bit into detail, little bit following up on Tridip's points about how the theocratic judgments, as I said, like the Ram Lalla idol, are being brought into this totally secular space, which is the real foundation of our constitution. And that is through a method which in a different context is referred to as heresthetics, H-E-R-E-S-T-H-E-T-I-C-S, heresthetics. Heresthetics is a term that emerged in the 1980s where political decisions are manipulated deliberately to get the result that you want. So you distort facts, you distort arguments, and you you develop a strategy to undermine decision making to get the result you want. Now, this is now I'm saying that what we are seeing the theocratic judgments doing is using judicial heresthetics. And a very good example, there are many examples of this, time is limited, I'll just use briefly with your permission, this Arub Bhuyan judgment. If you take the Arub Bhuyan judgment, you will see that the review judgment, you have this very interesting contrast to illustrate what Tridip was saying. You've got Arub Bhuyan original judgment, then you've got the reference judgment, and you've got the judgment of the review court. And it's the same set of issues. And what is the argument that the review court uses to overturn the original Arub Bhuyan judgment is where heresthetics is involved. They basically cite three reasons. One, they say that these Judge Indra Das and Arub Bhuyan, many of which are written by Justice Cjar, they use copiously refer to American judgments, and so that's not relevant to us in India. And they have a couple of other reasons also. They say, for example, that the constitutionality of the statute was not in question, so you should not have read it down. And the third reason is that you should not read down in the absence without the union being heard. But if you take the first argument, what they do is they create this red herring that American judgments are being used and American judgments are not applicable. And while there is a caveat that in some circumstances they may be applicable. But if you take the actual judgments, you will see that the American judgments put forward, if you look at the passages, the American judgment put forward unexceptionable normative propositions. Those normative propositions that are followed are based on democracy, based on the same principles as our constitution. And if this was an honest attempt by a court to challenge that, they should have examined those particular propositions which are anchored in many judgments of the Indian Supreme Court and asked whether those propositions are relevant or not to dismiss them. So they're raising a red herring argument that these are American decisions and using that to dismiss a set of propositions which are applicable. For example, the idea that if you prohibit, if mere speech is criminalized, the consequences will be completely perverse. That the authoritarian, you will have to have, so one example, one of the American courts, I think Justice, may have been, I can't remember which judge it was, he uses is that you'll have to have a swarm of spies because you have to know what people are saying because there is no action. So you'll have to have a swarm of spies in your country, and you'll completely transform the nature of your country if you're simply going to be criminalizing simple thought and simple speech without any specific action, and so on and so forth. Now, we also know that the famous dissent by Oliver Wendell Holmes in the Williams case, which is also referred to by Justice Cjar, was very important as a dissent in redefining the American jurisprudence on speech, on the basis that free speech is necessary for the government to know whether it is on the right track, because without the government's policies being openly and fearlessly criticized, the government itself will not know whether it is on the right track or not. And so it is essential for good governance to have this freedom of speech. Now, these are propositions that have to be debated by the judgment, and we have to be told why they are not applicable in our country. That our government has the capacity to make right decisions without hearing any criticism or questioning of those judgments simply because they are in power. And that, of course, is the heart of what is Hinduism. So what I want to say is two things. One is that what is going on in the country is, like it happened in the Babri Masjid, the idols of theocratic judgments are being put into the secular space. of the Constitution, and that is altering the nature of the Constitution, and it's only a matter of time before the structure of the Constitution is going to be brought down and a new Hindu Supreme Court is going to be constructed there. And secondly, the manner in which these heresthetics are being, the manner in which these judgments are being smuggled into this secular space is by engaging in heresthetics, which is really these red herring arguments, false arguments, incorrect arguments. And there the responsibility we have of all of us in the legal profession, law academics, lawyers, judges, I think we have all failed very badly, is that we have to call out every theocratic judgment, every theocratic argument. We have to rigorously call them out, and we have to communicate to the people of the country that these are theocratic judgments, and they are using heresthetics. In other words, they are using manipulative arguments. So if, for example, a doctor is writing prescriptions based on black magic and not based on medicine, it is only the medical profession that can tell the people that this doctor is using black magic and not medicine, medical science. So unless we as a profession, unless we go drill down and go into each of these judgments and question them. So the Arup Bhuyan review judgment, I may have missed it, but I personally have not seen any really clear analysis or criticism of that judgment in the public domain or even in the legal domain. So we have to take responsibility to challenge this. We have to be much more rigorous in our arguments, and we have to particularly insist and ensure that unwritten conventions on judicial and statutory and constitutional interpretation, both by lawyers and by judges, are scrupulously followed. Now that is a very small response to a very huge problem and may not succeed. But I think that is one thing we can do to make people understand that the system is no longer working in an honest manner and that it is being infiltrated and it is being subverted. So this is, I think, a big responsibility for all of us. We should fail. The last point I want to make, which we are pursuing very rigorously in some work we are doing in Kerala, for a reason that I'll explain, is that this entire attack is coming on the judiciary and the judicial system and the Constitution. The attack is on the Constitution. If you look at the civil and political rights that are being attacked, I've done an analysis of judgments. It's basically on three sets of rights. It's freedom of speech, it's freedom of association, and including forming trade unions, and freedom of assembly, of any kind of expression. These are the three rights that are being concentrated, attacked, because they want to silence speech, they want to to shut down mobilization, and they want to shut down any kind of dissent or protest in order to establish a Hindu Rashtra. That is the objective. We cannot lose sight of that. We cannot assume that simply making good technical legal arguments is going to save this battle. How do we fight this Hindutva battle against understanding that the problem we are fighting is not a wayward judicial system or a wayward legal system? It is the attempt to convert India into a Hindu Rashtra, which, as I pointed out, was evident right from the beginning. How do we counter that? Here, I would say that the entire political ideology of Hindutva and the entire political movement of Hindutva rests on one false assumption, that 85% of Indians are Hindus. There is only one voice that has countered this assumption, prominent voice. That was 100 years ago in 1925, on the 11th day after the RSS was inaugurated. Narayana Guru in Kerala issued a public statement saying there is no such thing as a Hindu religion. He said it is not a religion. And he explained why it is not a religion. And he provided a framework for understanding that it is not a religion. In a simple way, he explained why Hindu is a name of a group of religions, like Semitic is a name of a group of religions. I can't say my religion is Semitic. I have to be Muslim, Jew, or Christian to be Semitic. And I cannot be a member of all three and be Semitic, because they have commonalities, but they have irreconcilable conflicts. I have to be only a member of one or other religion. So Narayana Guru named 11 basically Brahminical religions, like Advaita, Dvaita, 11 religions he named. Vaishnava, Shaiva, Vedic, Pauranic. And he said Hindu today, he said at the beginning Hindu was a name used for the people in this geography, but today it is a name of this group of 11 religions. Unless you belong to one of those groups, and you cannot belong to more than one of those groups, you cannot say you are a Hindu. And today we are taking 85% of the people of this country who worship, who are actually have an enlightened spirituality. They worship everything they see. They'll go into a Shaiva temple, then they'll go to a Vaishnavite temple, they'll go to a church, they'll go to a mosque. Anything that there is divinity, they will accept and worship. Guru says that's a wonderful, enlightened approach to spirituality, but the name of that approach to spirituality is not Hinduism. It has no common name. It is the vacuum of the absence of the common name into which Hindu has been pushed in the last half a century to take over the space. And so he suggests that common name can be developed, like Manava Dharma and so on. But my submission is that unless we also from a constitution, the constitution stands on a social foundation. It mirrors society. We must understand this constitution is coming from this foundation of a misunderstanding of our approach to spirituality. And unless we correct that, we will not be able to tackle the root cause of the crisis that we are facing, and we will not be able to protect our constitution. As I said, we are working on this in Kerala. We are able to stave off Hindutva in Kerala because of these of Narayana Guru's the wisdom and the guidance that he provided to us. And we need also to link with that and deepen our struggle in the legal space also, to question and counter what exactly is Hindu in order to let people reflect on whether it provides an adequate basis for constructing a movement that is about to destroy the Republic. Thank you. Sorry, I went over now.
थैंक यू वेरी मच प्रोफेसर मोहन गोपाल। और आपने बहुत ही एक डिटेल और बढ़िया तरीके से हमें बताया है कि तानाशाही आ नहीं रही है, तानाशाही आ चुकी है। और आपने कहा कि दो तरीके की जजमेंट्स सुप्रीम कोर्ट से आ सकती हैं, एक जो संविधान के दायरे में हो और दूसरा जो धर्म के बेसिस पर दी जाती हैं। और आपने कहा कि 1950 में जब हमने संविधान को अपनाया तो धर्मनिरपेक्षता जो है वो एक बहुत ही अटूट हिस्सा है हमारे संविधान का। और आज हम देख रहे हैं कि किस तरीके से जजमेंट्स में, जहाँ पर कॉन्स्टिट्यूशन के एक फ्रेमवर्क में काम होना चाहिए, वहाँ पर ऐसा ऐसा धर्म की बेसिस पर चीज़ें हो रही हैं। आपने एक उसकी एनालॉजी दी कि जैसे मस्जिद में कहा जाता है कि कुछ आइडल्स मिल गए हैं हिंदू, तो उसी तरीके से अब ऐसा ऐसा वो उसको प्लांट किया जा रहा है धर्म को ऐसी जगहों पर जहाँ पर पूरा काम जो है, जो हमारे देश का संविधान है, उसके दायरे में होना चाहिए। और आपने कहा कि ये तानाशाही जो है ये हिंदू राष्ट्र के एक तरीके से अम्ब्रेला के अंडर आ रही है और तानाशाही आ रही है, हिंदू राष्ट्र का नाम बन रहा है, बनाया जा रहा है। और जैसे एक बड़ी इंटरेस्टिंग बात जो थी कि जैसे हम लेबलिंग देख रहे हैं लोगों की होते हुए जो आवाज़ उठा रहे हैं, उसी तरह से जो ऐसी जजमेंट्स हैं उनको भी लेबल किया जा रहा है जो कि सही वैल्यूज़ और प्रिंसिपल्स को एस्पाउस करती हैं। तो कहा जा रहा है कि ये तो अमेरिकन जजमेंट्स हैं, ये यहाँ पर इनका कोई मतलब नहीं है, जबकि जो उनके मूल है, जो उनके अंदर जो प्रिंसिपल्स लिखे हैं वो बहुत ज़रूरी हैं। और आपने यही कहा कि हम सबको इस तरीके की चीज़ों की खिलाफत करने की ज़रूरत है। शायद आज ये सेशंस जो बुलाए गए हैं वो उसी का एक हिस्सा है, जिससे कि हम सुन सकें, समझ सकें लोग कि क्या हो रहा है जुडिशरी में। और आपने ये भी कहा कि जिस तरीके के अटैक आज हम अपने मौलिक अधिकारों पर होते देख रहे हैं, सिविल लिबर्टीज़ पर होते देख रहे हैं, वो इसीलिए हो रहे हैं जिससे कि एक हिंदू राष्ट्र का निर्माण हो सके, और जिस संविधान को हमने अपने आप को अर्पित किया उसके दायरे से हम बाहर जा सकें, और जो तानाशाह जो इरादे हैं वो कामयाब हो सकें। सो बहुत बहुत शुक्रिया, थैंक यू वेरी मच प्रोफेसर मोहन गोपाल। आई एम नाउ गोइंग टू कॉल वरीशा फरासत. She's an advocate and practices in the Supreme Court, in the High Court, and Varisha has taken up many cases, including the Bhima Koregaon and the Delhi riots conspiracy case she's been involved in. So, Varisha, 12 minutes to you.
Yeah. Thanks so much. I'll try to finish very fast. A lot has already been said. I think the three speakers who went before me said a lot of things. I want to make a few points based on certain legal issues and some general observations. The first thing that I want to start with is that when we look at the CRPC is essentially the code that governs arrest procedures as well as investigation procedures, whether it's the ED, whether it's the NIA, whether it's the Delhi police. Any investigating agency is bound by the procedures that are laid down in the CRPC. But I think the most important thing to realize today is that so in the CRPC there is an inherent presumption that the police or the investigating agency are acting in good faith. Right? I think the code is there, but the code basically provides for a fair investigation process. I think we all have to, and I think even the judges have to now rethink how they will deal with certain cases where that presumption is completely overturned. In fact, the police are not acting in good faith. And so, you have that 6 months for UAPA for which custody can be taken, or you have 90 days for other cases within which charge sheet have to be filed. But when from the very beginning, from the inception, the police or the other investigating agencies, whether it's the ED, whether it's the NIA, whether it's the tax authorities, they don't act in good faith. Do people who have been incarcerated, do they even have to undergo that 6-month period? I think, there is so much disappointment amongst all of us lawyers who do bail matters for UAPA cases or PMLA cases or such things, that, the minute a client walks into my office who has been booked for UAPA, we'll say, let's not move bail for 6 months till the charge sheet is filed. That's how we are advising clients now. I mean, we are in a very serious situation. The minute a UAPA client walks into your office or an ED client, you say, let's not do anything until a charge sheet is filed. That's already, we are starting from a point of loss. We are not, and then as you go along the, higher courts and as you go along the appellate courts, sometimes something works in a particular case and you say, oh, we have a little victory here. But if you look at the bail jurisprudence and you look at how investigations are happening, and in fact, when we look at the Delhi riots cases, when we look at the Bhima Koregaon cases, when we look at some of the Kashmir cases, where journalists and human rights defenders have been incarcerated, there has been no fair investigation. And I'll just, I guess it's 4 o'clock, everyone's a little tired. But I don't know how many of you looked at the NewsClick case. Of course, it was a lazy line in the New York Times that got a full-fledged organization, news organization, that was working on crucial issues. NewsClick had done very interesting stories on farmers' protests. They had done very interesting stories on issues of poverty and so on. And suddenly, because of a lazy line in the New York Times, they are in jail. But I think if you look at the evidence, it's a little bit of a joke, right? Because if you look at the video, which is actually being used to implicate them, and to say that in fact, because of this video, NewsClick was doing Chinese propaganda. I urge all of you, after you finish today, please go and look at that video. It is, I think there are a lot of, senior people here, so you'll be familiar with Alam Ara, which was actually the first talking movie. So it's literally, the video is, no offense to NewsClick people who made that video, but that video is nothing. It's just a few scenes brought together with a little bit of, some sort of lines, etc., that are there on each of those pictures. It's not a serious video. If they had to, do Chinese propaganda, I'm sure they would have done a better job of it. That's where we are at. I'm saying, and for this prima facie, 6 months, charge sheet, it is absolutely a travesty of justice and nothing else. And I think that the Supreme Court previously, even when we look at terror cases, I think the Supreme Court has had the ability to be very fair. So when we look at the Adam Bhai judgment, which came many years ago, in that the Supreme Court not only acquitted all of the people who were there, but also said that the errant officers must be punished. So like I think the other previous speakers were talking about it, that the jurisprudence of the Supreme Court itself, until very recently, was about liberty and was leaning towards giving people their liberty, no matter what the offense was. I think those days are now gone. And I think Dr. Mohan Gopal was talking about the Arup Bhuya judgment. And so I think a lot was written about it. In fact, I did remember reading a lot about it. And he's absolutely right that the original Arup Bhuya judgment was actually premised on this guilt by association doctrine that American law had propounded. And it said that mere membership, therefore, cannot be held against you, and you cannot be penalized for mere membership. Now we know that, again, that judgment has been completely overturned. I will not go into too much detail of the UAPA cases and the ED cases and the bail provisions. Those have been discussed very well and very eloquently. But I do want to also talk about another case that has troubled me a lot, and that is in the Rohingya case, the Salimullah judgment, in which the Supreme Court order actually says that non-refoulement is not something that we are bound by. And I think it goes back to the Arup Bhuya point, that how can you not be bound by non-refoulement as the Supreme Court of India? Because it is part of customary international law. It doesn't even have to be written in your law that if a person who's going to be persecuted if he's sent back to their country cannot be sent back. How is it that non-refoulement is something that the Supreme Court of India is not bound by, is something that escapes, that I cannot understand. And in fact, there's also, on the Rohingya issue, there's also another judgment, which is ICG versus Gambia, which is given by no less than the International Court of Justice, to which India is also a party and has in fact sent a judge, which said that yes, there was genocide that is being committed against the Rohingya people. So we were on the back of 2 judgments. To say something like this, I think really shows that we are going back on certain issues, if not on everything. I want to now just, again, I mean, I think I don't have too much time, but I think this entire use of ordinances to defeat Supreme Court judgments is another trend that I think must be flagged. Whether it was the appointment of the Chief Election Commissioner or the JNCTD case, what the government does is, there's a constitution bench that has sat, and a constitution bench that has applied its mind, has given a reasoned judgment, has given a long judgment, and then you pass an ordinance that undoes everything. You know, I think the only other case I can remember is in the Shah Bano case, and how much we criticized it and said that how did the Rajiv Gandhi government bring an ordinance against the Shah Bano case. So these are the times that we are living in, and this is the interaction between the judiciary and the executive. And I think there are 2 quick other points I'll say. One is the question, and the other, I think, sort of red herring, in fact, which has gone unnoticed, is the entire question of FCRA. Because how do you control dissent? Is by controlling the funding. You control all of the organizations that don't agree with your point of view. And that's exactly what the FCRA amendments have done. In fact, the FCRA approvals have been cancelled en masse of many of the organizations that are perceived to be liberal by the government. And aren't these the cases that need to be looked at very quickly? Because there's also livelihood issues involved there. Because, and in fact, if you don't have the money, you can't propagate ideas. We live in a world where even to run a small organization, you need money. And again, I think for FCRA, I think the courts have done very little. Whether it's the high courts or whether it's the highest court of the land, I think they've done very little. It's something that needs our immediate attention also. And last, I just want to quickly stop, and I think, again, I think both Mihir and Pradeep talked about, UAPA cases, but we can't talk about UAPA cases unless we talk about Kashmir, unless we talk about the human rights defenders and the journalists who are there in Kashmir and who are suffering every day because of the impossibility of the bail, because of the threat of the bail, because of the threat of the UAPA. There has been so much self-censorship because it's not just that the people who you have put in, it's also about the fear that it creates amongst everyone who's outside, because they know that bail is impossible. So you curb dissent by making examples of people. And it's a very, very troubling, and in fact, I just want to talk about this one case because it's a young woman's case. I don't know how many of you heard of someone called Sana Irshad Mattu, but she was the first woman to win a Pulitzer Prize. I mean, as a woman, I feel extremely proud that someone who's from here, a Kashmiri girl, a young girl, won the Pulitzer Prize. But what did the Indian government do? They did not let her travel to receive her Pulitzer Prize. And so that is the level of vendetta that the government is showing. And ironically, I must say this, do any of you know the story for which she won the Pulitzer Prize? It was actually praising the Indian government for taking COVID-19 vaccines to rural parts of J&K. That is the irony of the times that we live in, that she's not allowed to travel, she's prevented from traveling for a story that actually praised the Indian government. No one is asking any questions, we don't know facts of any cases, Kashmiri, let her not travel. So that is the, unfortunately, these are the times that we live in. We can only flag these issues, and we hope that the judiciary takes note of them. Thank you.
थैंक यू वेरी मच वरीशा। और वरीशा ने अपनी बातें जोड़ी जो अभी तक पैनल से हमने सुनी थी उसमें, और कहा कि किस तरीके से पुलिस स्पेशली, बट और भी एजेंसीज, वो चाहे ईडी हो, इन्फोर्समेंट डायरेक्टरेट, चाहे एनआईए हो, वो किस तरह से गुड फेथ में एक्ट ही नहीं कर रहे हैं। और जवाबदेही जो होनी चाहिए है पुलिस की, जिसके बारे में पहले भी चर्चा हुई, वो हम देख ही नहीं रहे कि सुप्रीम कोर्ट भी मांग रही है केसेस के अंदर इन सब एजेंसी से। और आपने ये भी बात जोड़ी कि किस तरीके से एफसीआरए लाइसेंसेस कैंसिल हो रहे हैं, जो लोग आवाज़ उठा रहे हैं, ऑर्गेनाइजेशंस आवाज़ उठा रही हैं जिससे कि उनकी आवाज़ को दबाया जाए, वो भी एक मुद्दा आपने जोड़ा। और साथ में आपने कहा कि किस तरह से कश्मीर को हम नहीं भूल सकते हैं, जहाँ पर डिसेंट को दबाया जा रहा है यूएपीए जैसे कानूनों के इस्तेमाल से। जो ह्यूमन राइट्स के डिफेंडर्स हैं उनके ऊपर लगाया जा रहा है यूएपीए, जर्नलिस्ट्स पे यूएपीए लगाया जा रहा है। और सुप्रीम कोर्ट को बहुत कुछ करने की ज़रूरत है, और उन्होंने इसी उम्मीद के साथ अपनी बात ख़त्म करी कि ये सब आवाज़ें कोर्ट सुने, और जो अपेक्षा है लोगों की कोर्ट से एक डेमोक्रेसी में, कि कोर्ट काम करे, हमारे राइट्स को अपहोल्ड करे, हमारी सिविल लिबर्टीज़ को अपहोल्ड करे, वो काम हम जुडिशरी से होता देखें, सुप्रीम कोर्ट से होता देखें। बहुत बहुत शुक्रिया वरीशा। हमारे साथ कपिल सिब्बल जी जुड़े हैं, आपका बहुत स्वागत है। और उन्हें जाना है थोड़ा जल्दी, इसलिए मैं उनसे रिक्वेस्ट कर रही हूँगी कि वो आके बात रखें। मिस्टर सिब्बल नीड्स नो इंट्रोडक्शन, ही इज़ अ वेरी वेरी सीनियर लॉयर, he has been he's been the Minister for Law and Justice and is also fighting all these causes in the courts for us.
जहाँ भी जाते हैं बगावत की बात करते हैं। आप कोड ऑफ क्रिमिनल प्रोसीजर की बात कर रहे थे और कह रहे थे कि बड़ा अच्छा कोड है। यूएपीए की बात हुई, पीएमएलए की बात हुई, और मोहन गोपाल जी ने बताया कि केरला में क्या कर रहे हैं। But I have a real problem with all this. The problem is the following. When we adopted the Constitution of India, it was based on the 1935 Act. When we adopted the criminal laws, it was the same IPC, the same CRPC. When the British had this provision that you can arrest anybody on the basis of suspicion, why did the British do it? Because they wanted to quell dissent. They could just arrest anybody they liked. They didn't want people to speak up. They didn't want people to talk against the British government. And so many atrocities were committed based on this provision. I have a problem with this provision. How does it pass the test of constitutionality? You cannot be deprived of your life or liberty save in accordance with procedure established by law. And what is that procedure? Suspicion. I can suspect anybody I like. What's the basis of that suspicion? That's subjective. It can't be objective. There is no procedure to make it objective in the Code of Criminal Procedure. So I have a fundamental problem with the genesis of criminal procedures. And nobody has challenged it so far. And I don't know why. You prosecute under PMLA, you arrest him on suspicion. Then he can't get bail. You tell the magistrate, I suspect him. He says, what's the evidence? He says, I'm finding out. You had, under the code, you have 14 days. Now it's 30, 60, 90. It's up to 90. That, of course, law will not come into effect till 1st of July, but that's another matter. Question is, how does the magistrate decide that this suspicion is based on facts which can be demonstrated in a court of law? I don't know why you suspect me. I suspect you because you were there. Oh, I suspect you because you gave a speech in Mumbai. Oh, I suspect you because I know you are part of a conspiracy. Why do you suspect me? Because you made a phone call. This is the kind of evidence on the basis of which the prosecution relies to deny you liberty. So I think it's about time we started testing, questioning the very genesis of this code. And it will require a lot of public debate. Because if you arrest me, I don't know what the facts are. He doesn't tell me what the facts are. And even if the grounds of arrest are supplied to me, they are not enough for me to defend myself. And in some of these codes now, and some of these PMLA and UAPA provisions, especially PMLA, the judge has to be convinced that you are not guilty of the offense. Well, I don't even know what the offense is. So how do I convince the judge that I am not, or he gets convinced that I am not guilty of the offense? I don't know the facts on the basis of which, on suspicion, somebody has arrested me. So that's the first point that we need to look at as a matter of constitutional law. Is suspicion enough of a procedure? Or there is something else that needs to be elaborated and demonstrated for someone to have a reasonable cause for suspicion? What are the parameters of that? Will the court elaborate those parameters? The absence of which, according to me, this provision is unconstitutional. That's point number one. I'm sorry, I'm going to the genesis of all this because we've been discussing all these laws. Point number two. In which country do you get police remand? What do you mean by police remand? Means on suspicion, of which I don't know the facts, I'm going to be arrested by the police and kept for 14 days. What's the rationality for that? In which jurisprudence do you get police remand? No jurisprudence. In liberal countries, you investigate first, then you arrest a person, and you demonstrate that. In our country, you arrest first and investigate later. So this concept of police remand, I do not understand as a matter of constitutional law. Because police remand, what does it mean? That I will be in the custody of the police, incommunicado to anybody else. Why should I be incommunicado? I will not be told of my grounds of arrest because the charge sheet will be filed much later. I'll be asked all kinds of questions which have no relevance to the incident. And this is especially true in some of these very draconian laws. For example, take the PMLA. I'll just give you an example. You start asking him, you know you have no evidence against the man because for whatever reason, and I don't want to, give the reason for this, because we all know why people are arrested. But what happens is that you call a person, arrest him under PMLA, and you start questioning him. Now, I want to know, that's the third issue I want to raise. When you call somebody in PMLA for recording his statement, you don't know, the person who is called doesn't know in what capacity his statement is being recorded. Is he a witness? Is he an accused? He doesn't know. You just send him a notice. The ED sends him a notice saying, please come appear on such and such day at such and such time. I write to him and I say, look, tell me what the reason is. He said, no, you have to come. I won't tell you what the reason is. So what kind of procedure is that? Is somebody not supposed to tell me before arrest as to what's the reason why he wants to call me to arrest me? Is someone not supposed to tell me why he's calling me, in what capacity, with respect to what incident, with respect to what transaction? Am I not supposed to know? Have I no right to know? I'm not talking about cases where there is a murder and there are eyewitnesses and you go to the spot. That's a separate cup of tea. I'm talking about these so-called economic offenses and so-called offenses against the state, the PMLA, the UAPA. These are special laws with special provisions, draconian provisions. According to me, entirely unconstitutional. So what does a citizen do? He goes to the trial judge says, abhi to taftish honi hai, abhi to investigation honi hai, kya, kahe ko, are grant remand, 3 days, 5 days, 10 days, it will be 60 days, 90 days. The investigation will go on. And now it's a very interesting thing. Now they say, under the new laws which will come into force, that you can have a gap. आपको 2-4 दिन के लिए रख लिया, फिर 2-4 दिन के लिए छोड़ दिया, फिर 2-4 दिन के लिए दोबारा रख लिया. No rationale for it. So, that's the third problem. I want to know in what capacity I'm being called. Why do I want to know? If I'm being called as an accused, I can say I'm not going to answer any of your questions. If I'm being called as a witness, I must know why, in which capacity, what incident, what's my role. And as a witness, I have to go and I must go. But what they will do is they will arrest me first. In the meantime, record my statement and use that against me, knowing full well that you're calling me as an accused. It's absurd. Makes no sense. I mean, see, law is common sense. Law is nothing. You guys think that, we are learned lawyers. No, we're not. We're just simple, ordinary people who understand simple, ordinary things of life. And you apply them to a situation. That's law. When you read a statute, you use simple words, try and understand the basis of those words used in the statute and find out whether it's consistent with my constitutional rights or not. It's as simple as that. Right? Now, third issue, another issue. Under some of these special acts, you don't need to keep a diary. In the PMLA, UAPA, you don't have to keep a diary. Under the Code of Criminal Procedure, you need to record in the case diary every day what happened, who you visited, where you visited, which statement you recorded, all that stuff. No such thing. In other words, the more draconian the law, the less the protection. Is that consistent with the Constitution? How do the two match? So, I think that we as lawyers should start thinking of basic issues. Raise these basic issues in court. We take the law for granted, take its constitutionality for granted, and then we argue. It's an entirely wrong approach. Luckily, we have a constitution which has given us some rights. We must start with the proposition that this law, is it consistent with my rights under the Constitution? If it is, we collaborate. If it is not, we challenge. And we must have a fresh look at these things. And as lawyers, we must form groups to understand the nature of these laws, the impact of these laws, the consequences of these laws as they are put into action. And all that needs to be done by us. That's how, and that's why we need, through YouTube, through the social media platforms, this to percolate down to people, because unless you reach this information down to people, they will not know. Now, that's all I wanted to say just on the law. The fact, the fundamental issue is, if the system has no integrity, you can twist any law in the manner that you like. We've reached a stage in this country where systems have no integrity. The police has no integrity. Institutions have no integrity. And when I mean integrity, I don't mean individual persons. There will be individual persons in any system who are phenomenal human beings, who will try and protect you. I mean, as an institutional structure, this nation is losing its embrace to integrity. Now, when that happens, and if the police functions in accordance with the direction of the government in power, whichever government that may be, no law can protect you. So, the fundamental question that we must ask ourselves is, how do we ensure that people with integrity are part of the system? And there the problem of politics and money power comes in. This whole problem of these laws and corruption and money use and bonds, electoral bonds, and all that has come about. Why? Because in 1993, we liberalized the economy. We couldn't do without it, and we can't do without it. This liberal economy brought huge amounts of money in the private sector. So, in fact, we needed more systems in place to make the actions of government accountable, right? We forgot to do that. So the corporate sector, the big business had huge stakes in the economy, and they were willing to barter away their integrity. And people who were willing to, at the helms of power, were willing to barter away their integrity, right? For money. The electoral bond scheme was actually meant for that, which is Prashant beautifully argued that, look, we have a right to know who is given what. So, one, good people must get into politics, must risk that journey, as some of us have done. And the middle class must raise its voice, which has succumbed. It's lying prostrate before the powers that be. 3, lawyers, no matter which political party they may be inclined towards, must speak in one voice, because you're a lawyer first and a politician later. Why? Because your duty is towards the people. This is a service industry. It's not a business. We've made lawyering as a business. How much money will I earn today? And the moment you do that, you're not a lawyer. You're just as good or bad as any other businessman. And it is the lawyers that can lead from the front. And I think that these gatherings should inspire us to actually take the message across the country. We need to spend some time giving up our time for going around the country and explaining that we as lawyers can lead the nation as we did when we brought freedom to this country. Let us march along for yet another freedom that we need and require and espouse for and look for.
थैंक यू वेरी मच मिस्टर सिब्बल. आपने सवाल उठाया सिस्टम पे, तरीकों पर ही, और आपने 3-4 चीज़ों के ऊपर हमारी अटेंशन फोकस किया. एक तो कि जो पूरे शक के बिना पे लोगों को जेल में डाला जाता है कि कुछ किया उन्होंने, उसका कोई एविडेंस नहीं है लेकिन शक है, और ये स्पेसिफिकली उन्होंने यूएपीए पीएमएलए जो ऐसे कानून हैं जिसके अंदर जो ड्रैकोनियन कानून हैं जिनमें बेल मिलना बहुत मुश्किल है, उसमें आपने कहा कि शक के बेसिस पर केवल, और ये तो पूरी तरह से एक कॉलोनियल माइंडसेट है कि अगर कोई बाहरी ताकत हम पे शासन करे, वो कहे कि हम शक करते हैं और उसके बेसिस पे हम आपको अंदर डाल रहे हैं, वो एक चीज़ है. लेकिन यहाँ पर शक के बेसिस पर ये सब कुछ हम होते हुए देख रहे हैं, किस तरीके से जो हमारे सिविल लिबर्टीज़ को के लिए बोलने वाले जो तमाम लोग हैं उनके ऊपर अटैक हो रहा है. आपने कहा कि पुलिस रिमांड में रखा जाता है, कोई एविडेंस नहीं है, इन्वेस्टिगेशन नहीं होता है प्रॉपरली, और उसके बिना ही अरेस्ट हो जाता है. अरेस्ट के बाद पुलिस रिमांड में रखा जाता है और वहाँ पर किसी से आप बातचीत सही से नहीं कर पाते हैं. ये सब कुछ शक के बेसिस पे किया जा रहा है. और आपने कहा कि जब बुलाया जाता है लोगों को तो पूछताछ के लिए, स्टेटमेंट रिकॉर्ड करने के लिए, तो हमने बार बार देखा है कि बताया ही नहीं जाता कि वो विटनेस के लिए तौर पे बुलाए जा रहे हैं कि अक्यूज्ड के तौर पे बुलाए जा रहे हैं. तो क्या स्टेटमेंट लिखवा कर फिर उस स्टेटमेंट को यूज़ किया जा रहा है इन इतने गंभीर मामलों में? डायरी रखने की ज़रूरत नहीं है यूएपीए पीएमएलए. तो ये जो सारी तमाम जो प्रॉब्लम्स हैं, ये एक तरीके से जो हमने अभी तक सारी बातें सुनी कि उसकी ओर लीड कर रही हैं. और आपने ये कहा कि ऐसे जब सिस्टम नहीं है और सिस्टम में फिर इंटेग्रिटी नहीं है, पुलिस को जिस तरीके से काम करना है वो नहीं कर रहे सही तरीके से, तो फिर हम एक्सपेक्ट नहीं कर सकते कि कानून हमारे को प्रोटेक्ट करेगा. और जो हम संविधान की बातें सुबह से सुन रहे हैं वो फिर केवल किताबी रह जाती हैं. और आपका बहुत बहुत शुक्रिया कि आपने इन सब इश्यूज़ के ऊपर भी फोकस किया. थैंक यू वेरी मच मिस्टर सिब्बल. I now request Mr. Chandaruday Singh. C.U. Singh ji he's a very senior lawyer. He's been taking up cases of many people, many cases very successfully, and others where we are all still struggling. He's been taking them to the courts, to the Supreme Court, and you're welcome. Thank you very much for joining us today. A round of applause for Mr. C.U. Singh.
Thank you, Anjali. How much time do I have? I'm going to concentrate on some of the areas where the Supreme Court is perceived to be backsliding, or where we have this very unfortunate trend of going one step forward and 2 steps back. And sometimes when we are very fortunate, then 2 steps forward and only 1 step back. But the step backs, unfortunately, have been very frequent. And so I'm just going to focus on 4 or 5 of these. The first is a very disquieting thing which has happened. It's happened twice or thrice, I think, in the last 2 or 3 years. But the most recent time it happened was when a bench of the Supreme Court in Ritu Chhabria delivered a judgment on the 26th of April 2023, holding that if that under 167 2, which is of the CRPC, which is what we call the default bail provision. That if as Kapil was saying, we have a provision that you arrest people on suspicion. You conduct the entire investigation after that, and actually you are so invested in that person who you've arrested. You means the prosecution is so invested in it because they've put their reputation on that. So by hook or by crook, they want to bring the case home against that person. They don't investigate anybody else because they've sort of invested themselves in one particular person. Now, here what the Supreme Court found in Ritu Chhabria, it's not as though they laid down some absolutely new law. They just found that the default bail provisions were being sought to be defeated systematically. But default bail works on a basis that once the investigation is complete, if the investigation, if the time given is 30 days, you have to complete the investigation and file the challan or charge sheet within 30 days. If it's 60 days, you have to complete it within 60 days, 180 days, etc., 90 days, 180 days, because under UAPA, you can get an extension to up to 6 months. But if the challan is not filed on that 180th day, 90th day, whatever it is, then the person who is incarcerated is entitled to bail as a matter of right, regardless of all other the merits of the case, which we call default bail. What the Supreme Court found was that to defeat 167(2), the prosecuting authorities were filing an incomplete charge sheet, deliberately incomplete charge sheet, where, welcome Justice Patnaik. So the court found that an incomplete charge sheet is filed, and the very words of 167(2) are that on completion of the investigation, the charge sheet will be filed. Now, 173(8) allows you to also continue an investigation under certain limited grounds, even though you have filed the charge sheet. But what they were doing was taking advantage of 173(8). They would file an incomplete charge sheet, making it very, very clear that the investigation was not complete and that they were still going on with the investigation, but just to defeat the default bail. So the Supreme Court said in Ritu Chhabria that this is 167(2) has been read by the Supreme Court to be part of an Article 21 right. It's fundamental to your right under Article 21 of freedom. So they said that this kind of practice of filing incomplete charge sheets will not be countenanced. You have to complete the investigation and file the charge sheet. You may still have a 173(8) option under the circumstances which are available over there, but you can't file an incomplete charge sheet just to defeat default bail. 26th April is this order. 28th April, the Delhi High Court, coincidentally a matter was being heard and this judgment was shown to them. They followed the judgment of the Supreme Court. On 1st May, a mention is made before the Honorable Chief Justice, who was coincidentally on that date sitting in a 2-judge bench by the Solicitor General of India, and on a mentioning it was ordered that no court in the country will decide any matters on the basis of Ritu Chhabria. And they said, the union said, we are in the process of challenging the Delhi High Court order. So on an oral mentioning, this order is passed. It's kept on 4th April. By 4th April, they bring this DE versus Manpreet Singh, somebody or the other, Talwar. They bring that matter against the Delhi High Court judgment. Again on 4th April, it happens to be a 2-judge bench configuration. So they continue that order that no court in the country to consider default bail based on Ritu Chhabria. It's kept on 12th April, on which date a 3-judge combination is there. The 3-judge combination says that we continue that order now. But we make it clear that all courts can continue to hear default bail matters and grant default bail, but without reference to Ritu Chhabria. So now this is a new form of jurisprudence where one bench of the Supreme Court stays another bench, de jure, de facto, whatever, there's actually a stay of a judgment by one bench of the Supreme Court. So this is, I'm just flagging certain areas where I'm saying these are areas which are of great concern, and this is backsliding. In the normal course, this would have come before a bench, the bench would have heard the matter, and the bench would have said, look, I disagree with that view. and therefore I request the Chief Justice to constitute a larger bench, and I refer it to the larger bench. The larger bench in due course would be constituted, they would hear all parties, and they would either agree with the particular view or disagree with the particular view. But this thing of just on an oral mentioning staying a judgment, and this was the second or third time this happened, I don't want to go into details, but this here is the thing, 26th April, 28th April, 1st May. Bang, Ritu Chhabra no longer exists. So this is one. Then we have like Arup Bhoya, which has been pointed out, 2011 is the judgment in Arup Bhoya, followed by Indra Das, etc. And ultimately this comes before a 3-judge bench on a reference, and the 3-judge bench in 2023 overturns the 2-judge bench. But I'm on the principle. The principle here is that the 3-judge bench, in essence, forget about anything shorn of all the verbiage, the 3-judge bench says that actus reus and mens rea are not needed for a criminal offense in respect of section 41, section 20 of the UAPA, which means that where you are alleged to be a member of a proscribed organization or a banned organization, there's no question of actus reus, no question of mens rea. This is virtually setting, virtually throwing into the dustbin the Universal Declaration of Human Rights in 1948, which we are signatories to. It discards every principle of criminal jurisprudence that we have held dear in this country, and that has been ascribed, that has been, found to be fundamental to Article 21. That guilt by association is enough, is what the Supreme Court is saying. So forget about the fact that they might have found it unpalatable that you relied on an American judgment, or the Union of India was not a party, or whatever. But what are you saying at the end of the day? You're saying we subscribe to, we endorse guilt by association. We endorse the fact that you can lock somebody up and throw away the keys without mens rea, without actus reus, without committing any act at all. Just passively by existing, you can be locked up forever. That's what the Supreme Court is saying. Now these are trends. This is not. So then we come to the third one, which is section 19 of the PMLA. Now on section 19, the Supreme Court on 3rd of October 2023 gave what I consider to be a very salutary judgment in Pankaj Bansal. The Supreme Court said that, look, 19(1) says that on the basis of materials in his possession, having reason to believe, brackets, the reason for such belief to be recorded in writing, that any person has been guilty of an offence punishable under this Act, he may arrest such person and shall, as soon as may be, inform him of the grounds for such arrest. Now this is followed by subsection 2, which says, immediately after the arrest of such person under subsection 1, he shall forward a copy of the order along with the materials in possession to the adjudicating authority in a sealed envelope in the manner as may be prescribed. And 3 says that every person arrested shall within 24 hours be produced before the special court or the metropolitan magistrate, etc., as the case may be. So what did the in Pankaj Bansal, the Supreme Court said that when you have to provide when you have to record the reasons in writing before the arrest, 2, you have to inform the person of the arrest as soon as maybe you have to inform him of the ground of the arrest, and immediately after the arrest, you have to, in a sealed envelope, send those grounds for arrest along with the materials to the jurisdictional magistrate. And 3 says that within 24 hours you have to produce him. So they said the only logical interpretation of this is that at the time of the arrest you have to furnish him with the grounds in writing, because you've recorded the grounds before arrest. And note, it says as soon as may be. Now what is as soon as may be? If I've recorded it, as soon as may be means at the time of arrest. Because what other meaning can be given to the words as soon as may be if you had to record it before? Secondly, if you produce the person within 24 hours, which you have to do minus the travel time, and you've not furnished the person with the grounds of arrest, how will that person fight against remand? On the basis of memory? Because the earlier view was that orally you can just tell the person. Right. Now this judgment comes and strikes down the arrest on the ground that you have not furnished the grounds in writing. This I said was on 3rd of October. 15th of December comes a judgment, and the alacrity with which, setting aside judgments by equal benches seems to be this trend. Now, on 15th of December, we get a judgment in Ram Kishore Arora. Ram Kishore Arora takes the view that this is a two-judge bench, Pankaj Bansal is a two-judge bench. Ram Kishore Arora takes the view that Pankaj Bansal did not properly follow Vijay Madanlal Chaudhary, which was a three-judge bench. They refer to per incurium at certain places, and later on, having talked about per incurium, now firstly, even if it was per incurium, you have to refer it to a larger bench. Per incurium cannot mean that you just disregard a coordinate bench. But having used the word per incurium at one point, later in the judgment they say Vijay Madanlal didn't consider this issue of as soon as maybe. They said Vijay Madanlal Chaudhary did not decide the interpretation of what is as soon as maybe. It did not decide. Vijay Madanlal only said that the ECIR, which is the formal, which is not the grounds of arrest which you have to record, the ECIR, which is ultimately the formal substitute for the crime report in lieu of the FIR, that need not be given to the accused. Vijay Madanlal didn't consider 19(1) in this context at all. But so having said that, having then refused to follow Pankaj Bansal, this bench then goes on to say, no, but they still have to give it within 24 hours. So you needn't give it in writing at the time of arrest, but you must give it in writing within 24 hours. But that then defeats the remand provision in 19(3), because if I have to give it in 24 hours in writing and I have to produce you in 24 hours, that means I can produce you in 23 hours without giving it to you and get a remand order, and then half an hour after the remand order I can give you the grounds in writing, which is what is going to happen in every single case. Now, what is the tearing rush for one bench of the Supreme Court to do this whole judicial acrobatics just to take away a basic fundamental right of a citizen to know what the citizen is being arrested on? And especially, mind you, 90% of these people who are being arrested, now I'm not talking about chief ministers and all, who seem to be the favorite target under PMLA nowadays, but 90% of the people are illiterate. If they're told orally or they're told to read grounds, how much are they going to remember? You're arrested, you're already panicky, you are cut off from your community, you're cut off from your family, you're cut off from everybody, and you're expected to remember grounds which are shown to you. Your signature is taken or your thumb impression is taken at the foot of those grounds. So when there's an absolutely salutary judgment, the Supreme Court rushes in. Oh, danger to society, because we've done something good for an accused person. Let's quickly nip it in the bud. This is point number 3. The fourth one, which again is really, actually this is horrifying, that people who are granted bail after 5 years and 6 years of incarceration, the high courts now have started this thing of granting bail after meeting the most horrendous after crossing the most horrendous obstacles, which would even put a sort of a black cat marine to shame. He wouldn't be able to cross such an obstacle path, but you cross all those obstacles and you finally get bail, and the High Court then stays the bail order for 1 week. This happened with Mahesh Raut. I'm talking about the Bhima Koregaon 16. This happened with Gautam Navlakha. In both the cases, the High Court stays it for 1 week or 2 weeks. Immediately, the Supreme Court continues the stay without a hearing. So, Mahesh Raut gets bail on 21st of September 2023. He has been incarcerated for 5.5 years by then. Najib has kicked in, everything has kicked in, and he gets regular bail because he was denied default bail despite seeking to rely on the Sudha Bharadwaj principle and so on. But that's all history. He gets regular bail. The High Court stays it for 1 week. The Supreme Court immediately admits the appeal. But they admit the appeal not because the appeal deserved admission. They admit the appeal because they said, we can only hear matters on Wednesday and Thursday if we admit an appeal. Because if we don't admit the appeal, Tuesdays we have a very long list. So we can't hear the matter, so we'll list it on, to list it on a Wednesday or Thursday, we admit. They do this, and then till today, the person is still behind bars. Gautam Navlakha, ditto. Still behind bars. Of course, in Gautam's case, apparently he is on house arrest, so at least he has some relief, but he remains incarcerated. Now, these are certain instances of complete backsliding, and I don't want to, we are very short of time. Justice Patnaik has just come in. So I just want to flag these and keep them with you, but we have to speak up, we have to articulate this, and I agree with what Professor Madan Gopal said, that all of us perhaps need to start writing more, analyzing more, and bringing these things, these sort of trends to light. Thank you.
Thank you very much, Chandar. And आपने जो ट्रेंड्स हैं उसको बहुत ही खूबी से कैप्चर करा है 4 जजमेंट्स के जरिए से। ऋतु छाबड़िया, जहाँ पे आपने कहा कि डिफ़ॉल्ट बेल का जो प्रोविज़न है कि कितनी मुश्किल से बेल मिलती है, डिफ़ॉल्ट बेल का जो प्रोविज़न है उसमें अगर इनकम्प्लीट चार्जशीट फाइल की गई, कहा गया ये नहीं सही है, तो उसको किस तरीके से स्टे दे दिया गया इफेक्टिवली, और ये किस तरीके से हनन है हमारे अधिकार का। 2011 का जो अरूप भूयान केस है, जिसके बारे में पहले भी चर्चा हुई, लेकिन गिल्ट बाय एसोसिएशन, क्योंकि आप किसी के साथ जुड़े हैं, काम करते हैं, केवल उसी से ही आपकी जो गिल्ट है उसको इस्टेब्लिश कर दिया जाएगा। धारा 19 PMLA से रिलेटेड जो केस है पंकज बंसल का, आपने बताया कि रीजंस रिकॉर्ड होने चाहिए अरेस्ट के, उन्हें देना चाहिए जिसको अरेस्ट किया जा रहा है अरेस्ट के समय पर। और ये जो है जो पूरा का पूरा सिस्टम है कि जब किसी को अरेस्ट किया जाए PMLA में, तो कम से कम उन्हें जानकारी हो कि क्यों उन्हें अरेस्ट किया जा रहा है। वो भी जो है कह दिया गया कि अरेस्ट के समय ना दिया जाए, 24 घंटे बाद दिया जाए। तो रिमांड का जो ऑर्डर है वो 24 घंटे से पहले अगर कोई ले ले तो मुझे मालूम भी नहीं होगा कि अरेस्ट क्यों किया गया, ग्राउंड्स फॉर अरेस्ट। और फाइनली जो आपने बेल के ऊपर बात रखी, जहां पर ये कह दिया गया है, जहां पर बेल इतनी मुशक्कत से मिलती है और इतनी मेहनत के बाद PMLA UAPA जैसे केसेस में बेल मिलती है और फिर उस बेल के ऊपर ही स्टे कर दिया जाता है, जैसे हमने देखा गौतम नवलखा और महेश राउत के केस में। तो ये जो सारी चीज़ें हैं ये एक तरीके से दिखा रही हैं कि जो सुप्रीम कोर्ट का रवैया जो है, जिसके बारे में हम चर्चा करते आ रहे हैं, सिविल लिबर्टीज़ को लेकर, हमारे राजनीतिक अधिकारों को लेकर क्या हो रहा है। तो बहुत बहुत शुक्रिया आपका फॉर शेयरिंग ऑल ऑफ दिस विद अस। We are now joined by Justice A.K. Patnaik. I welcome you, Justice Patnaik. He is a former judge of the Supreme Court of India, has served as the Chief Justice of the High Courts of Chhattisgarh and Madhya Pradesh, and was also the chairperson of the Odisha Judicial Academy and executive chairperson of the Odisha State Legal Services Authority. I request you, Justice Patnaik, to kindly come up here and share your thoughts with us.
Good afternoon to you all. First of all, I must tell you, after I retired from Supreme Court, I thought Supreme Court was doing a good job. it will continue to do a good job then. Well, good number of good judges then. Then I thought, I have no savings, hardly a few lakhs in my savings account. 2 lakhs, to be very precise. I must earn some money and make some savings. And therefore I went in for arbitration. Then I did arbitrations right from 2014. This is 2024. Then when I saw personal liberties of citizens being affected, Supreme Court delivering all kinds of judgments, people showing their concern. Wherever I went, they say, what is happening to the Supreme Court? I thought I must wind up my arbitration practice, which now I am winding up. And now I have decided that I would like to participate in some of these debates and create opinions to ensure that our Supreme Court and the High Courts are backed to exercise their powers. I was listening very keenly to Mr. Singh, C.D. Singh, senior advocate, to various judgments and how the Supreme Court is taking a view. And in contrast, I was reminded what I witnessed as a lawyer in the Supreme Court way back in 1980s. I was sitting in the court of Justice Chinnappa Reddy, and some other judge was sitting with him. And a preventive detention matter was there. A Sikh gentleman was arguing, maybe for his relative or his friend who was inside. And his only ground was that I have not been given a right to make an effective representation. He said, why you have not been given? Yes, I have been given. You have not been intimated the grounds. I have been intimated the grounds. But the materials that were given in support of the grounds are not legible. Justice Chinnappa Reddy, I was watching with what sensitivity he took up the matter. He said, do you have the materials with you now? Those stamped materials which were given to you in support of the grounds? Yes, I have them. Can I have a look at them? He passed on the materials. He looked at the materials. He was shocked. He said, he had a tremendous sense of humor. He said, I thought only judges in the Supreme Court were privileged to receive illegible documents filed by lawyers in support of their cases. I did not know detainees are also suffering this. They said, all right, take it down. In 10 minutes, give a dictation, quash the order of detention. And I was then a lawyer. Whichever court I went at that time, I found fantastic judges. I remember I was sitting in the court of Justice Venkatramaya and Justice Faizan Mustafa Ali. And a Maharashtra Standing Council, Master Government Standing Council was arguing a case. Somebody had been sentenced for bigamy. He had a wife whom he had abandoned, and he had got married to a 50-year-old girl, right? But the accused had filed a petition, please commute my sentence. I am prepared to pay some money for the first wife. Right? And the Maharashtra Standing Council said, no, we should not leave this man. Why he had committed a grave offense of bigamy. Then the judges said, this is where Mustafa, he said, when your actors and actresses do in Bombay, in Maharashtra, you don't do anything. I don't want to name. Right, he named also. Right. But when this poor man does it, you are after him. See, look at the consequence. If you punish him, both the wife, first wife, second wife suffer. Because the earning paper is out. If you get the money, he was offering quite a substantial money, and give it to the first wife, let him go to the second wife, then both the ladies are saved. You see, I am giving these instances to show what the judges were then. Different approach altogether. And that is the way one has to look at the different laws in the light of what Mr. Singh said, Article 21, Article 22. You can't forget them. You can't look at the law and just decide and take a view. Those laws are there, have to be interpreted in the context of the constitutional rights. We cannot forget them. The judges cannot forget, and particularly Supreme Court judges cannot forget, that Article 32 is a very rare provision in the Indian Constitution, which, despite the fact that the High Courts have been vested under Article 26 to enforce fundamental rights, Supreme Court has also invested with the power to enforce fundamental rights. And as far as the earlier decisions are gone, we used to examine it with a lawyer. When it comes to enforcement of fundamental right, the Supreme Court cannot say no. It's a duty to examine and enforce it. Cannot say no, you go to the High Court. But we have seen some instances the Supreme Court says no, you go. In some instances they enforce it. This should not happen. Everybody expects that this is. Frankly, those people who can afford it, they come to Supreme Court. And these days, because of institutions like Common Cause and other institutions which are taking up these small the cases of the poorer litigants, and legal aid is also there, they can come to Supreme Court. But fundamental rights cannot be bypassed while interpreting statutory provisions. And when it comes to a statutory provision and the fundamental rights, one has to, as far as possible, read down the statutory provision to give way to fundamental rights. This should be the approach of the courts. Now let me just read a few provisions of Article 22, which he was also mentioning, that grounds of arrest are not intimated. So Article 22 of the Constitution, who says, no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds of such arrest. Nor shall he be denied the right to consult or to be defended by a legal practitioner. Now, orally, whether he informed the grounds of arrest or not, it becomes a disputed matter. Completely disputed matter. So, I think it will be proper for the court to say, give it in writing, please. Says there is no dispute about that. This is a constitutional protection. Then, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for journey from the place of arrest to the court, the magistrate, and no such person shall be detained in custody beyond the set period without the authority of the magistrate. What does this provision show us? Constitution itself has a provision which suspects the executive authority. Therefore, produce him before the nearest magistrate. I remember when I was first posted in Guwahati High Court, I was surprised the first 9 writ petitions that I read before I went to the court, and that is the Disturbed Areas Act was in force, I just could not believe that such things can happen. First 9 petitions, same wordings. There was a knock at the door at midnight. I opened the door. I found an army officer standing, and he asked for my son. And I said, yes, my son is there. He took him into custody, arrested him, and left. First 9 petitions. All sons being picked up midnight by army officers. Let me tell you, I thought, where have I come? I have never seen this kind of petition to Orissa. Where have I come? Then I went to the courtroom. Justice Phukan was there, my acting Chief Justice. I said, what is this? This is what it is in Assam and the Northeast. I said, what do we do then? A simple order we pass. We pass an order, produce it before the, hand him over to the police. That is the provision. Army has to hand over with the police immediately, and police is to produce it before the arrest magistrate. That interim order has to be given. That order is passed. We passed. Then they filed a reply. All the 9 dead. All the 9 youngsters dead. What? They were not picked up from their house. This is the denial. They were not picked up from the house. They were killed in encounters. They were there in some insurgent activity, and we were killing them, and they were killed in the field. Just imagine what can happen if these constitutional checks are not thought of. What can happen? I would rather suggest that many of the judges who come to Supreme Court must go get posted to places like Guwahati High Court, Manipur High Court today, and all these interior areas. Then only they will think what liberty means, what right means. And frankly speaking, I became more sensitive because I was posted in Guwahati High Court for 8 long years. Had I not experienced all this, I would not be so sensitive to rights and liberties of people and the life of the people. Then, you see that the advisory board is there, and this provision is the advisory board retention. You must have seen all those judgments on preventive detention of the Supreme Court. I don't know how many youngsters have seen them. All those judgments of preventive detention, Article 22. Right. How strict the Supreme Court was. One defect, one particular provision, either of Article 22 or 4, not complied with, or any defect with regard to the Act, that time it was National Security Act, 1980, previous then MISA, one defect quashed the order of detention. Why? Why was the Supreme Court doing this? Because I used to think also why the Supreme Court is doing it, then I can understand. They are very sensitive to liberty. At no cost, liberty of the citizen can be sacrificed. Now the Supreme Court has, in Maneka Gandhi, expanded Article 21, procedure established by law has become procedure established due process of law. But earlier it was procedure established by law. And procedure established by law means law. Law has to be followed. And law has to be interpreted consistent with personal liberty, Article 21, 22, and so forth. Article 20. You cannot sacrifice that. They are very important. Very, very important. So, what I was saying is that while interpreting the provisions of Money Laundering Act, while interpreting the various provisions of any of these, anti-terrorist law, they have to be very, very careful. They cannot say because terrorism is there, we must say, because money laundering is taking place. No. See, the role of court is entirely different. And I would like to make this point very strong. And if I was there in the Supreme Court earlier than many of the judges who took up many cases in the Supreme Court, very early in Guwahati I studied, the role of court is not to prevent corruption. The role of court is not to prevent money laundering. The role of court is not to prevent terrorist activity. That is the role of the legislature and the executive. They have to be accountable. The role of court right from English days is there as a check on the legislature and the executive to ensure nobody's personal liberty or life is affected. This is a very fundamental thing which I am sorry to say many of us in the Supreme Court have forgotten. You to go to British courts, dicey, rule of law, courts, parliament, legislatures, they and executive, they have the role. They are accountable to the people if they are not preventing corruption. They are accountable to people if they are not preventing, not allowing these people who are laundering with money, with crimes, are not arrested. They are accountable to people. But court's job is not that. If the court start thinking, if I were to think all the time, I have to ensure the corruption stops. I have to ensure that money laundering doesn't take place. My interpretation will go wrong. I have to ensure that, yes, legislature's job is to do this. But at the same time, there should be sufficient checks and balances to ensure that, number one, personal liberty is not affected. Number two, an innocent man is not put behind. This is what I think. Once your thinking cap changes, your approach in the courtroom will also change. Now, you see, look at the English people. Section 25 of the Evidence Act. Confession before a police officer is not admissible. Why? As a student tries to question it. Why confession is not admissible? Somebody has confessed. Why it is not admissible? Because they distrusted the police. Coercion. Police will put the coercion, put the lathi, put the gun and get something written to you. That distrust is there. Where is this distrust now? In the acts. Same people are there. Narcotic Act. I was sitting in a bench where somebody had been a statement under section 15 of the narcotic officer. Somebody gives a statement and records it. On that basis, conviction. As bad as section 25. So when the matter came before me, they cited a judgment of Kabir. It upheld this view. There were two judges, we were also two judges. I told Justice Sikri, let us refer it to a larger bench. I don't think a statement recorded by a narcotic officer should be a ground to detain someone on the Narcotic Act, right? Or to punish him. 10 years is the minimum. So, he wrote the order, let us grant him bail. We granted bail. Mr. Sushil Jain was, I think, arguing the matter. Referred to a larger bench. And larger bench, with Rohinton as presiding, said, yes, this view is correct. A statement recorded by an officer under the Narcotic Substance Act cannot be a basis for, right? I don't know whether it's struck down or no, I don't remember. But he took that view. So we judges have to be sensitive totally sensitive. And we judges can't leave to the legislature or to executive to protect the liberties and life of the people. That is primarily the job of the Supreme Court to ensure that. Bail matters. It's normally the approach in the Supreme Court was, if the High Court had granted bail, don't interfere. Don't interfere. I'll give you an instance. One matter was transferred by the Supreme Court from UP to Madhya Pradesh. Right. Mr. You must be knowing Raja Bhaiya case. Right. Father and son were involved. The Madhya Pradesh High Court, another bench, he granted bail to Raja Bhaiya. The matter came to Supreme Court. Justice B.N. Agrawal and Justice Mathur were sitting there. B.N. Agrawal said, how Raja Bhaiya was given bail? We must interfere. Justice Mathur said, how do we interfere when we have laid down the law ourselves? Normally a bail matter will not be interfered with. Right. Lot of restraint sometimes Supreme Court has to. We can't act on suspicion. The suspicion of the judges were that the judge must have been dealt with by granting bail. Right. But let's not go on that. For to do one thing here, why should we sacrifice a principle? Principle is bail granted by the High Court, don't interfere. Acquittal by the High Court, normally don't interfere. All those principles are laid down. Go by principles. Then only you save the institution. If you go by individual, this will happen. What will happen? One judge come, he takes another view. Another judge come, he takes. No. We have to go by principles. Right? If we follow the principles all through, judgments are there. If one judgment is not holding good, two judges, three judge bench you refer it to. That is the law. Follow it. Three judges have referred to larger bench. Five judges follow it. Follow it. That's very important. Go by principle. Don't bring in your individual predilections, individual prejudices, individual influences, individual favorites at the bar to do this. If you do that, then you will be ruining the Supreme Court as an institution. Now coming to the solutions, as first of all I would say we must ensure that judges become sensitive to liberties. How to do it? We must do it. We must become sensitive to it. And unless judges are very sensitive to rights and liberties of the people, we can't have judges. Just knowledge will not do. Just brilliance will not do. Most important thing is your commitment to protect the rights and liberties of people and to do justice in the case. That's the most important qualification of a judge. Second, we must have a very independent bar. What by independent bar, I don't mean only from the executive, also from the judges. I entirely agree that a lot of your matters come before the judges of the Supreme Court. Therefore, you should be respectful and all that. But respectful does not mean going out of the way and going around the judges, giving them unnecessary importance, praising a judgment which is not really correct and good. If the judgment is not good, please go and tell them, sir, I read your judgment. Doesn't take care of liberty and rights of the people. That courage the judges member should have. The bar or don't say anything at least. Don't go and keep on saying. I remember once a lawyer was mentioning to a judge that, sir, you have written a good judgment. This thing. Behind him was Mr. Kapil Sibal. He was listening to all that. And behind Kapil Sibal, I was standing there in a party. Then as soon as the judge shifted, Kapil Sibal was scolding him. He said, क्या ये judgment लिखा तो उसको प्रेस कर रहे हो? क्यों प्रेस कर रहे हो? I said, if Kapil was doing the right thing, please don't do that. But you may lose some cases here and there, but never do that. That flattery of a judge has to be avoided. Apart from independent from the executive, you have to be an independent judge. Absolutely independent. I have noticed here, everywhere, people will circle around a sitting judge. He retires, then he's gone. Then members of the bar will second round or retired judge. Don't do this. Have your self-respect. You are invited to and good. Because they get inflated. They don't even know that they are not performing performing well in the court. You follow. This is very, very important. This is a very important thing I'm telling you. Then third, regular seminars like this one. Discuss. Also report to the newspapers that this is what's been discussed without, referring to any individual judges or individual politicians. But let us protect the rights and liberties, institutionally discuss it in principle. And create opinion. Create opinion. Strong opinion. Maybe in discussions on television, maybe in writings. Many youngsters are now writing in the papers. Don't think judges don't read. When I was a judge, I used to read very often. And after reading, I have also corrected my judgments. One judgment I have reviewed mine, Right to Information Act. This is my colleague wrote it. Then I read it. It is not a good judgment. Then review was filed. Both of us were there. Then I took a different view altogether and reviewed the judgment. Right. And my colleague said, all right, sir, you do one thing, let me retire. With the next judge, you write it, I sue that's with Justice Sikri and review the judgment. We correct ourselves. We correct ourselves. And I've cited that famous words of Justice Bhagwati in Antule case. Antule case, the Supreme Court decided the High Court will hold the trial. Antule filed a review. No, High Court trial. Why is the question of High Court trial? Special judges to try. And an appeal lies to the High Court. The High Court tries and lose one appeal. Right. Then, in the Antule case, again they sat down and decided, the Supreme Court says, the earlier we correct our mistakes, the better it is. So, by these debates, the judges will realize, and earlier they review it, their thoughts, the better it is. Thank you. Thank you very much.
Thank you very much, Justice Patnaik. That was very, very useful. और मेरे ख्याल से जो एक अगर पंक्ति में इसको मैं सार बताऊं तो जस्टिस पटनायक ने यही कहा कि जो हमारी जुडिशरी है, हमारे कोर्ट्स हैं, सुप्रीम कोर्ट है, उसका काम भ्रष्टाचार को रोकना, टेररिज्म को रोकना केवल ऐसे नहीं देख सकते हम, वो तो है ही, लेकिन सबसे ज़रूरी काम है राइट टू लाइफ और राइट टू लिबर्टी को प्रोटेक्ट करना। तो जब तक कोर्ट्स से हम ये बार बार नहीं कहते हैं, और ये जो पूरा आज के दिन का चर्चा हुई और स्पेशली इस सत्र में जो डिस्कशन हुई, जस्टिस पटनायक ने जो बात रखी, आज सुबह जस्टिस जोसेफ ने भी कहा कि अभी जो हम ट्रेंड देख रहे हैं सुप्रीम कोर्ट में, शायद ये दिख रहा है कि पहला हिस्सा अनुच्छेद 21 का, आर्टिकल 21 का, राइट टू लाइफ का तो समझ में आ रहा है, लेकिन राइट टू लिबर्टी जिस तरह से अपहोल्ड होनी चाहिए वो नहीं हम होते हुए देख रहे। तो आपका बहुत बहुत शुक्रिया जस्टिस पटनायक फॉर जॉइनिंग अस टुडे एंड फॉर शेयरिंग योर थॉट्स विद अस. Round of applause for Justice Patnaik, please. I understand that we are running short of time. We have another session as well. I'm going to request Indira and Amrita to please come and read out the resolutions. And if there are any questions, then the panelists are also here. Maybe those could be taken up as well.
Thank you very much. We'll request the panel to stay on here and we'll first open it up for some questions and comments and then we'll go into the resolutions. We've got a request from the court employees. जो court employees पंजाब हरियाणा हाई कोर्ट से हैं, उन्होंने रिक्वेस्ट भेजा हुआ है कि वो कुछ कमेंट या क्वेश्चन, आप लोग हैं क्या? तो अब तक हम माइक पहुंचा रहे हैं. And सबसे request, if your question can be sharp or if it's a comment, it should be brief, please. Thank you.
हेलो, सदन में सभी को राधे राधे. न्यायपालिका सभी को न्याय देती है, तारीख भी देती है, लेकिन अपने अधीनस्थ कर्मचारियों का शोषण दिन प्रतिदिन बढ़ता जा रहा है. हमारे लिए स्थानांतरण के प्रार्थना पत्र माननीय उच्च न्यायालय इलाहाबाद में 8 वर्षों से विचाराधीन है, जिनका निस्तारण नहीं हो रहा है. हमारे कर्मचारियों से सुबह शाम घरेलू कार्य किया जाता है. अगर वो कर्मचारी नहीं करता है, जैसे सोनभद्र में घटना हुई, उस कर्मचारी के साथ मारपीट की गई. एक ऐसी महिला है जिसने अपने अधीनस्थ अधिकारी पर कुछ आरोप लगाते हुए उसने अपना रिजाइन दिया और मुख्यालय अध्यक्ष ने उसका इस्तीफा स्वीकार कर लिया गया, जबकि किसी बेस पे कोई ऑब्जेक्शन लगा के अगर वो कर्मचारी इस्तीफा दे रहा है तो उसका इस्तीफा स्वीकार नहीं किया जाता है, क्योंकि उसकी कंडीशन देते हुए उसने ऐसा किया था. वो लड़की थी, लेकिन फिर भी उसका इस्तीफा स्वीकार कर लिया गया, जबकि ऐसा नहीं होना चाहिए था. हमारा शोषण दिन प्रतिदिन बढ़ता जा रहा है. घरेलू कार्य है, ट्रांसफ़र का है, एक एक कर्मचारी पर 3-3 हज़ार फाइलों का बोझ बढ़ा हुआ है. फिर भी हमें न्यायिक कर्मचारी नहीं माना जाता, हमको गैर न्यायिक कर्मचारी माना जाता है. एक तरफ हम शासन के अधीनस्थ कुछ समस्याएं रहती हैं, कुछ हमारी हाई कोर्ट से रहती हैं. तो क्यों ना हमें दो जगह पीसना पड़ता है, हमें केंद्र के अंदर ही कर दिया जाए या हमें फिर हाई कोर्ट के अंदर ही कर दिया जाए. हमारा सबसे बड़ा शोषण यह है, कुछ बात हमारी अपनी राज्य से होती है, चाहे वो कोई भी स्टेट हो, और कुछ उसकी हाई कोर्ट से होता है.
ठीक है, थैंक यू. हम पैनल से रिक्वेस्ट करेंगे रिस्पॉन्स करने का. एनी अदर क्वेश्चंस? कोई और सवाल? या वी कैन टेक वन क्वेश्चन देयर एंड वन देयर.
May I?
हु हैज द माइक?
मैडम, मैं आरटीआई एक्टिविस्ट हूँ और साइंटिस्ट हूँ. कैंसर की दवाई मैंने इन्वेंट की है और मेरे को एक केस में फंसाया गया था. उससे पहले हमें नहीं पता था कोर्ट कचहरी में क्या होता था. हम भी सोचते थे कि जज और ये भी सब ईमानदार होते हैं, यहाँ भी कुछ ईमानदारी कदर होती है. जब वहाँ मैं गया, मैंने देखा किस तरह तक गड़बड़ियाँ होती कि मैं सवाल उठाता गया. तब मेरे पर 4 बार अटेम्प्ट टू मर्डर करवाया. फॉर्चुनेटली जेल से बच गया. अभी भी मुझे 205 दिन तक जेल में डाला गया. जेल में इलाज तक नहीं करवाने दिया गया. और वो ऐसा सब करवाने में जज इन्वॉल्व है, पुलिस इन्वॉल्व हो. पुलिस की कोई दिक्कत नहीं है, पुलिस को सब गालियाँ, लेकिन जज जब ऐसा कर रहे हैं. फॉर्चुनेटली मेरी बेल होगी, हाई कोर्ट से नहीं हुई, लोअर कोर्ट से ही बेल होगी.
तो हम पर्सनल मतलब केसेस नहीं ले पाएंगे. आपका यदि कोई सवाल हो पैनल के लिए तो
मैं जस्ट एग्जांपल बता रहा हूँ किस हद तक हमारे लोअर कोर्ट्स में गड़बड़ी हो रही है. उसके समाधान के लाखों लोग ऐसे हैं, कोई मेंटली रूप से परेशान हो रहा है, कोई कैंसर से अलग अलग बीमारियों से शिकार हो रहा है, शोषण हो रहा है, सुसाइड कर रहे हैं. लेकिन उसको रोकने के लिए हमें सबको पता है, सुप्रीम हाई कोर्ट लिखते हैं, सुप्रीम कोर्ट लिखते हैं, आर्टिकल 235 की बात कर देते हैं. सुप्रीम कोर्ट की जजमेंट फॉलो नहीं थी, हम सुप्रीम कोर्ट को बात करें कि हाई कोर्ट को बात करें, उस पर कोई नहीं सुनता. लिखे जाओ. अब कोई पैसे वाला तो वो तो सुप्रीम कोर्ट आ गया, जिसका काम धंधा डिस्टर्ब हो गया सब वो कहाँ जाए. तो उनके जो करप्शन के इशू हैं, यहाँ तक तो बहुत सारे लोग फिल्टर होकर आते हैं जिनके पास कुछ रिसोर्सेज हैं, लेकिन जो नहीं पहुँच पाते वो करोड़ों लोग हैं। उनकी प्रॉब्लम के जो उनके पास अलग अलग जुडिशल करप्शन से पीड़ित हैं, उनके लिए अगर कोई ऐसा एक कमेटी बना दी जाए या कोई ऐसा प्लेटफॉर्म बन जाए जहाँ पर वो अपनी प्रॉब्लम रख सकें और उनसे रिलेटेड कोई समाधान, आप लोग सारे हर तरह से इस लीगल फर्टिनिटी के सारे रिनोन लोग हैं, इन्फ्लुएंशियल हैं, पावरफुल भी हैं, आप उसके लिए कुछ समाधान दे सकते हैं जो देश के लोगों को बहुत सारी मदद हो सकती है। लोग सुसाइड कर रहे हैं, उसके लिए अगर कुछ कर सकते हैं
ठीक
तो
है,
उसके लिए
थैंक यू। There's a question right in the front and then there was one in the middle that Reed pointed and then we'll have to, yeah, you and then right. Please make it a question or a very, very brief
Yes,
comment.
good evening. Thank you so much. These are all like conversations that we keep having, but hearing it at a platform like this is equally grounding and shattering. But a question is, what do you think the role of legal education institutions are within this, playing a role with facilitating more conversation? I went to Jindal Global Law School, which houses some of the most interesting academics, but has recently in this last week suspended 2 students for discussing the Ram Mandir issue and a student discussion. So with the boom we've had in legal education, with so many lawyers being produced, what do you think the role of these institutions should be to harbor a greater amount of thought and integrity and discussions such as the ones we're having today?
Thank you. And the last question here, right in the front.
I actually have 2 questions, but I'll make them very brief. One, there's been a recent trend of judgments which are commenting on the nature of PILs and are understanding that a lot of progressive sort of human rights advancements have happened through PILs. How do we understand that and how do we comment on that? The second issue that I wanted to ask as lawyers who've been practicing and judges, that how much of this that we are seeing in 2024 is a reflection of 70 years of sort of infringement of rights of the marginalized, which are now being now coming up into other classes which were earlier protected through political or other hegemony.
From the panel, Justice Patnaik, would you like to address?
Ask.
Can you get the mic across? This is the last question that we'll be able to take today. Thank you.
My question is very specific related to the UAP Act. See, under 43D, there is a term used, prima facie true, that this kind of term is not used anywhere. So my legal understanding says there is also provision under 43E which provides some presumptions of commission of offense under section 15 of UAP Act. So how we can put forth our case before the courts on the by reading it both the provision together? The prima facie true has to be considered when such kind of material is available against the accused persons. That is my question, why it has not been put forth so far.
Yes, Mr. Siyusan.
Yeah, on the last question, I'll just take that first. See, prima facie true is used as one of the qualifications that bail will not be granted under 43D5 unless 2 additional circumstances over and above the CRPC are fulfilled. 1, that the prosecutor is given prior notice of the bail application, and 2, that the court finds has reason to believe that the charges are prima facie true, and so this actually puts a burden on the court to only examine the material and to come to a prima facie finding that they are true, unlike the earlier draconian laws which we had, where the court was to find that the person was prima facie not guilty. Here there is a positive burden on the court to come to a conclusion that there is some prima facie truth in the allegation. So in other words, the court is not supposed to just blindly say that whatever is alleged has to be taken as gospel truth. The court has to independently apply its mind, and in 2 or 3 judgments in Thwaha, Fazal, in Sudesh Kedia, and more recently in Vernon, the Supreme Court has clearly said that the court has to examine all the materials and come to a prima facie finding, not a conclusive finding, not a finding beyond reasonable doubt, nothing of that sort, but the court must prima facie satisfy itself. It must reasonably hold in its own mind that the allegations are prima facie true before it can deny bail. If it doesn't meet that threshold, then it comes back to only the CRPC provision. The special hurdles which are created by 43D5 would not apply. And so I think your question will be answered if you read the judgment in Vernon versus State of Maharashtra, Thaha Fazal and Sudesh Kedia. By and large, you'll find the answer to that.
I think your question also pertained to the presumption when something is found on the person, and that presumption links the person to the UAPA crime, arms or such like material. So you have to start on the premise that it's a draconian provision and such a provision is wrong. But having said that, presumptions do exist in law elsewhere. A registered document is presumed to be correct. A check is presumed to be that which is given for consideration, and the burden in a sense shifts on the person who issued the check to sort of literally to say it's turned on its head. Having said that, I'd request you to look at situations where the presumption is based on a rational construct. A registered document, a check, a degree from a college. When somebody questions your qualification, you produce a degree. There is, if the university confirms, sometimes the university doesn't confirm degrees. It happens. I don't know why you people are laughing. Now, if the process by which that document is obtained or the place is reached is reasonable, rational and legal, then I would go with the presumption. That is check, sale deed, degree, what have you. But in this case, I find it draconian. But all the same, I don't think it totally shifts the burden of proof. If you read MS Narayana Menon versus State of Kerala, which says that it's just a starting point. It still doesn't mean that the burden is on the accused. So it depends on where the arms were found, whether it can be linked to him, etc., etc. That will get into your facts. Yeah, it's not a bail condition, it's a trial condition. Bail condition is your 43D5, for which also you have to start with the presumption that it's a draconian provision. Unfortunately upheld throughout Kartar Singh, PUCL, whatever.
Justice Patnaik, would you like to take on any of the questions? Yes.
Mics are as unpredictable.
Hey, what was your question, the PL? And second question. No, so far as PILs are concerned, you know who was the basic brain behind PILs in the Supreme Court? P.N. Bhagwati. This P.N. Bhagwati. And I remember when I was Chief Justice of Madhya Pradesh, I had come for some meeting here in Vigyan Bhavan. By that time, the PILs were being abused, very badly abused. Not all PILs are abused. Many PILs are very good PILs. He said it's weaker sections, somebody has to come for them. Right? Common rights of workers, poorer classes, particular class actions, very good PIL. But some were motivated PILs. Supreme Court said, this is Prasad judgment, Paisa litigation. Somebody pays money and you go. So they have classified, for example, one matter, age of Mr. the General V.K. Jain, what is his name? Who is now a minister? V.K. Singh. So that matter, his age matter came before us, me and Justice Kapadia. Justice Kapadia asked me, I said, why should this be a PIL? Let him file an individual litigation, that is a service matter. There can be a PIL here, right? So one has to distinguish which really is a PIL, which is not a PIL, and that depends on the judge's mind. They should be able to assess which is a genuine PIL, maintain it, and deal with it. Which is not a genuine PIL, right? Throw it out.
I think we have right here sitting in front of us one gentleman who has filed and brought so many successful PILs.
No, his PILs,
recently
common cause PILs, I have dealt with them. Very genuine ones. I don't know.
Have just been set aside
I was there, pre-lunch session, I was there in Gurgaon in a meeting. So I was telling them the Association of Democratic Reforms. One Association of how they got together, they approached Bishop Bhushan and they fought the case and they got a good judgment. It's a good PIL, right? But there are also PIL which are useless. Say somebody, I'll tell you, I'll give you an example. Say some hotel is coming up there. Another rival doesn't want that to come. So he will put somebody as a PIL petitioner in Madhya Pradesh and file a PIL petition. Later on, will come to know that the rival has financed it. What do you do? This is a PIL. He doesn't want to come out in the open. So one has to distinguish. Regarding marginalized societies, marginal sections. See, I think in this field, Supreme Court has done a wonderful job. We have Part 3 is fundamental rights. Part 4, which is direct principle of state policy. If you look at the Constitution, what are the provisions in Part 3? They are all enforceable. Article 14, right to equality. Article 15, right against discrimination. Article 16, equal opportunity in public matter, public employment. Right. Article 17, untouchability. Article 18, no titles. Article 19, the freedoms. Article 20, all those checks, self-incrimination, all that. 21, liberty. 22. These are all enforceable. You don't require financial resources to make it through. They are there. They are rights. You can come to court and court can issue a action. Now, those which require financial resources, they are being put in direct principle of state policy. Right. And there is provision not enforceable. So, all the socio-economic rights that are there, right to livelihood, right to various provisions, they are all there in education also, up to age of 14 years. They were all there in direct principle of state policy. Supreme Court has done a wonderful job. Supreme Court has going on expanding Article 21. Some directive principle of state policy, they have put that up from that and incorporate Article 21. For example, the right to education, unification case, up to the age of 14 years, was Supreme Court contribution. Right? You read the judgment, Supreme Court contribution. And there they have said, now financial resources are there. Earlier it was not there. Now, thereafter Article 21A came in. Because it got planted in Article 21. Then Supreme Court, right to environment, which he pleads a lot. Right to environment. Supreme Court has incorporated Article 21, right to environment. 48 had come later on. But in Article 21 is there. They are enforcing it. Otherwise, the environment can't be enforced. Therefore, Supreme Court has going on expanding. And I feel that expansion should go on as much as is permissible. But what is not permissible, how can the Supreme Court do? It is given to the executive. It is given to the legislature under Article 37, I think, to incorporate that in their legislation and policy making. If they don't do it, and they don't bring in this equitable distribution of wealth, instead they are influenced by a different kind of policy, privatization policy.
Justice Patnaik, can we request you to wrap up,
There is
please?
not a problem. Not a problem. So Supreme Court has been doing a job. Primarily the executive has to take on.
Thank you. Thank you so much. Perhaps part of the question was also coming from the fact that very often the obvious ambush petitions are not struck down, but the genuine ones are. So we'll now move ahead with the resolutions from the Senate.
I would first of all like to thank each of the speakers and the members of the audience for their participation. It's been repeatedly held as a very basic principle that justice must not only be done but seem to be done as well. It must be tangible, palpable, visible. It must live and breathe. Some contributors to injustice lie in the roster management and case listing, as well as denial of his civil liberties and constitutional principles. Yet, I'm glad that we're talking about the elephant in the room today, debating it and bringing different perspectives to it. Once we've named the problem, clearly identified possible steps towards resolution, and it becomes the harbinger of change. Once we come together and collectively and openly talk about it, fearlessly, we open the door to transformation. So, with the energy of hope, I read the first few of our resolutions. These have evolved from today's discussion, from the topic and all your participation. So, the Supreme Court's judicial, administration and management and recent trend in cases involving civil liberties and political rights to restore the flagging public confidence and credibility in the judiciary with respect to perceived arbitrariness in listing and bench allocation to have predetermined outcomes, we, the members of CJR and participants of today's seminar on 24th of February 2024, do declare as follows. The first resolution: the present system of roster selection by the Chief Justice of India, acting alone, gives unfettered and unquestioned absolute powers to one individual and is not in keeping with settled principles of democracy, as it lacks transparency, participation and accountability, and is subject to gross misuse. Therefore, clear rules regarding regulating the functioning of master of the roster must be prepared on the basis of the following principles. The power and duty of master of roster must be exercised collectively by the 3 to 5 senior most judges, including the CJI. The criteria for roster selection must include area of specialization, experience in subject matters, area of work and diversity, region and gender. The basis for roster selection, including for constitution benches, and minutes of discussion for selection must be clearly recorded in writing and published on the Supreme Court website. In case of recusal by a judge, the case should get allocated to another bench dealing with the same subject matter as per the published roster. The roster for 6 months ahead must be published clearly on the Supreme Court website. So that's the first resolution relating to master of the roster, a more collective approach, a consultative approach. Second, cases must be allocated to benches solely on the basis of automatic computer allocation with the prepared and published roster. Any instruction given to the system for allocating cases should be publicly disclosed. No discretionary powers to be given to the Chief Justice or the filing counter to bypass the computer-based allocation system. In extraordinary circumstances, if an amendment is required after allocation, it must solely happen on the basis of discussion by the 3 to 5 senior most judges, including the CJI, and for reasons recorded in writing and disclosed publicly. Once the matter is allocated to a bench, it must proceed without any interference by the CJI or registry, and cases must be listed following a calendar for various stages determined in consultation with the concerned counsel or parties. Thus, bench allotment and listing for all matters fresh and pending must strictly adhere to the rules and norms set out above to address the anomaly of variability in listing and of some cases swiftly, while other cases languish for years, as well as with regard to case pendency. Thus, the discretion in roster selection is to be balanced by randomized selection within the roster through computerization. The third resolution, the procedure for mentioning urgent matters must return to the earlier system where matters were mentioned in an open court before the Chief Justice of India or the senior-most bench on the judicial side available to enable judicial orders to be passed for listing that bind the registry to follow these orders. And the fourth, there needs to be an effective and time-bound system for grievance redressal regarding case allocation and listing if there is any departure from rules and norms. Over to Amrita.
So these were the resolutions from the first session, and we take your silence as your consent, or by a show of hands you could show your consent, since the resolutions are collectively in the name of every individual and every concerned person who's attended and who's on the panel as well. From the second session, the resolutions are, the first one says, every case pertaining to personal liberty, especially for bail in pre-trial arrests and habeas corpus petitions, and for those related to fundamental constitutional principles such as federalism, cases must be taken up promptly and heard without any delay or unnecessary adjournment. If you're in agreement, by a show of hands, if you could please show that. Thank you. The sixth one says that the judiciary must immediately prohibit the practice of staying bails granted by lower courts merely because an appeal against it is pending before it or before a higher court. Such restrictive orders strip away basic liberty rights by placing unconstitutional and unjust barriers to fundamental rights, constitutional guarantees, and civil liberties. Through the panel, we've heard continuously how in different cases, even after you get bail, it gets stayed. So that's the sixth one. If you could do a show of hands to please pass this resolution. The seventh one says that the Supreme Court must urgently and critically examine restrictive conditions of bail in draconian laws with reasoned orders. The principles of speedy trial and bail, not jail, must be restored as settled jurisprudence. Executive violations must be immediately addressed and nipped in the bud to ensure accountability. Thank you. And the last one, which we had a big debate over whether or not to include it because it's in a way stating the obvious, but perhaps we've reached a stage where stating the obvious is required. So the last one says that the Supreme Court must publish settled judicial and legal principles that uphold people's rights, personal liberty, and fundamental constitutional principles, and honor and abide by them without diluting them and passing judgments inconsistent with them. Thank you. So we'll invite Indu to please give the vote of thanks on behalf of Cjar.
Well, good evening, friends. We have come to the close of the day. And surely, I think at the end of the day, you all are tired, but I know that you're all refreshed because we had a very exciting session from morning till now, from about 10 o'clock till about, it's going to be 5:30, more than 5:30. Just to tell you here that, we have esteemed panelists here, that CJR, Campaign for Judicial Accountability Reforms, completes its 20 years this year. So we have been in 20 years from 2004 onwards. And as a vote of thanks, I want to just say here that we thank all the speakers, Justice Madin B. Lokur, Justice Kurian Joseph, Justice Rekha Sharma, Ms. Kamini Jaiswal, Ms. Meenakshi Arora, Mr. Gautam Bhatia, Prashant Bhushan ji, Justice Anjan Prakash, in the first session they were there, and of course, I think Sharil and Alok were part of the CJR introductions and moderation. We also thank Justice A.K. Patnaik, Professor Mohan Gopal ji, Mr. Trideep Paes, Kapil Sibal ji, Chandra Uday Singh ji, Mihir Desai, and Ms. Varisha Farasat for taking us through this entire sessions. So a big clap for them. And then of course we have our Anjali Bharadwaj and Prasanna who took us through this entire discussion, moderated the session. The word of thanks will not be complete if we don't thank Shubhra Verma for designing the poster and the banner for this seminar. I think it put everything together. So thanks to her for that. Then a big thanks to all who came here by their own expense, and they made their own travel, and I think they came here to speak and be part of this seminar. So a big thanks from Cjar for all of you. Thank you, everybody. A big thanks to Anurag, Ria, Surur, who managed the hall, who managed seeing that there's no inconvenience here as such. Team of reporters need to be thanked, Luma, Ananya, Deb, Dutt, and volunteers, and Ronak, of course. And of course, we also want to thank Prashant Bhushanji's entire staff for making this workshop a success. And of course, also a thanks to LiveLaw and Wire. And a big thanks to, in fact, LiveLaw for live streaming, so that people who couldn't come here were witnessing it. And thank you for this big work you have done. And a big thanks to all of you sitting here. Without you, this seminar would not have been successful. So please join us next year again and be part of the resolutions. And a big round of applause to all the people here and there together. Thank you. God bless. Zindabad. Thank you.